can't go on. It's more what's the solution type thing. But the other thing is like
good afternoon. Just give everyone a second to settle in. There are still a few more people getting registered, but I guess I'll begin with my introductory remarks. Good afternoon, ladies and gentlemen. On behalf of the Cardozo Arts and Entertainment Law Journal, I'm pleased to welcome you to the Cardozo School of Law for what should be a very informative discussion on the merits of a proposal to reform U.S. law and policy relating to the international exchange of cultural property, a white paper by William G. Pearlstein, which advocates that United States cultural policy is in need of reformation. Before we begin, I'd like to thank our sponsor of the program, the Committee for Cultural Policy, with special acknowledgement to Kate Fitzgibbon for her extraordinary work in coordinating these panels. Additional thanks goes to the staff and editors of AELJ for their hard work in both editing the white paper and preparing for today's event, and to Professor Jean Schroeder for referring Mr. Pearlstein and the paper to us. Just a quick note about the index cards. If you have questions for the panelists at any point, please jot them down on those cards, and ushers will be walking up and down the aisles to collect them. The first mention of cultural property in AELJ goes back to our second volume, published in 1983. And since 1994, we've published over 40 articles on the subject from stalwarts in the field, including Patty Gerstenblith, David Rudenstein, John Merriman, and Derek Fincham. AELJ was the first journal of its kind devoted to arts and entertainment and has remained a leader in this field for over 30 years. It's fitting that Mr. Pearlstein and the Committee for Cultural Policy was introduced to AELJ, as AELJ and Cardozo have been heavily involved in this academic debate since at least 2001, when AELJ planned a symposium and devoted an entire issue to reports from the front lines of the art and cultural property wars, and hosted a roundtable entitled, "Who is Entitled to Own the Past?" Reviewing this issue published 13 years ago, I was struck by the similarity in this policy debate, with the only noticeable difference being that we have a lot more examples to speak of today. 13 years ago, Professor Rudenstein opened the roundtable with the following. The remarkable thing about this topic is that the interested communities in this broad field have deep suspicions of each other and don't necessarily engage in collegial dialogue with one another. That condition allows universities to come forward and play one of the more constructive roles that universities can play in a society like ours. Universities can be kind of a neutral meeting ground where people with strongly opposed views can come together and exchange ideas. Cardozo hopes to be able, in the years ahead, to do more of that in this art-rich city, which is not only a center of culture for the United States, but as many people think, for the world. Today, we continue in that grand tradition and further the academic discussion about the interplay of cultural objects and international trade policy at Cardozo in the safety of this university setting. Mr. Pearlstein's paper suggests the following 5 reformations to create consistent U.S. policy relating to these objects. These can be found in the executive summary that you picked up at check-in. The first of these is to amend criminal law, including reviving and passing Senate Bill 605 of 1985, which would amend the National Stolen Property Act to provide that no archaeological material taken from a foreign country claiming ownership shall be considered stolen if such claim is based only upon an act or declaration by the foreign country meant to establish national ownership of the material, or is the alleged act of stealing is solely based upon an illegal export of the material from the foreign country. Second, ensure that customs practice conform with U.S. law, and when the forfeiture doctrine is applied, it complies with the basic requirements of the decisions reached in Schultz and McLean. These elements that should be applied are whether the foreign law includes a clear and unambiguous declaration of national ownership, or is domestically enforced, or was in effect on the date of export, or whether the importer knew or consciously avoided knowledge of the applicable law at the date of export. Next, the next reform is to ensure that the legal requirements of the Cultural Property Implementation Act are followed. The CPIA implements the 1970 UNESCO Convention in the United States, and while 125 countries are signatories to the UNESCO Convention, the U.S. must enter into bilateral agreements with other member countries to enforce the import restrictions. Mr. Pearlstein proposes that new binding guidelines are needed to ensure a neutral interpretation of the CPIA and fair administration of the Cultural Property Advisory Committee, and that stewardship of the CPIA be moved to the Department of Commerce. The fourth reform suggests limiting the Justice Department's use of the Archaeological Resources Protection Act of 1979 to materials found on land owned or administered by the U.S. government or Native American tribes. And finally, the last reform proposes the creation of an electronic database of objects to ensure transparency, restore liquidity, and to provide repose. The terms and conditions of such a database would need to be binding on foreign and domestic governments and agencies to ensure its effectiveness. It's a lot of reform. It's in the executive summary that hopefully you picked up. Today's forum has been organized to discuss the merits of the paper and these reforms, and Mr. Pearlstein will begin our afternoon with his views on the state of affairs and what led him to write this white paper. Mr. Pearlstein.
Thanks very much. Good afternoon. My name is William Pearlstein. I'm a partner in Pearlstein & McCullough, a new art law firm. I've been practicing in the international art trade for almost 20 years. When one of my UK clients asked me why it has become so difficult to do business in the US, I said that US law governing the antiquities trade has evolved in a completely different direction than what was originally intended. That's the short answer. The white paper is the long answer. Let's agree that archaeological looting is bad, but that's where the discussion begins, not where it ends. There are probably 5 basic points of view. Cultural nationalists say that artifact-rich nations have the right to nationalize every cultural object within their borders, in or out of the ground. Most source nations have some sort of national patrimony law. In general, constructive ownership and theft are created by legislative decree and not by taking an object from an owner's physical possession. Cultural internationalists say that the lawful circulation of objects among nations serves a universal educational and civilizing purpose. Should this circulation be limited to government loans to museums, preferably universal museums that promote Enlightenment principles, or should it also promote private ownership and a legal market? Archaeologists say that the preservation of archaeological context is the preeminent policy goal. Only objects discovered in virgin stratigraphic context preserve the full spectrum of information for scientific analysis. Objects without context are stripped of meaning and devoid of content. Unprovenanced antiquities are inherently suspect, presumably looted, and must be shunned. The archaeological goal is to reduce demand by enforcing the national retention of cultural materials. The late Andre Emmerich expressed a free market position. Emmerich, an important dealer, scholar, and connoisseur, said that whoever is willing to pay the most for an object should own it. In this view, the preservation of the object is paramount and context is secondary. Emmerich wrote that multiple finds often yield redundant objects and repetitive, duplicative context. The archaeologist shudders, but is Emmerich wrong? The view that an object's aesthetic qualities and art historical value are preeminent probably prevailed through the early 1980s. Only thereafter did the view come to prevail that objects should be valued foremost in context as scientific data points. Finally, there's a middle way that tries to balance the competing demands of cultural nationalism, cultural internationalism, archaeology, and private ownership. The U.S. started down this middle path. The U.S. sent a distinguished delegation to Paris to negotiate the 1970 UNESCO Convention, including Paul Bator, a Harvard law professor, and Mark Feldman, a then young State Department lawyer. UNESCO is heavily weighted towards cultural nationalism. Archaeology is hardly mentioned. In a sense, UNESCO is moderate. It focuses on objects that are important to the national heritage and contemplates private ownership and export markets. Nevertheless, the U.S. delegation would not allow the U.S. to hand a blank check to foreign nations and automatically enforce their patrimony laws. Implementing UNESCO into U.S. law took 13 years. This process pitted the State Department against the cultural internationalists and free marketeers led by New York Senator Moynihan, Professor Bator, and a New York-based dealers group, including Emmerich. They were concerned that absent meaningful checks and balances, state would succumb to temptation and trade import restrictions on cultural objects for concessions and other foreign policy issues. When Congress passed the Convention on Cultural Property Implementation Act in 1983, the internationalists thought they had won. The U.S. would not hand a blank check to foreign nations. The CPIA's concept of stolen property is limited to theft from inventory, not theft by decree. The U.S. would reserve judgment on foreign requests for import restrictions. These would be limited to culturally significant archaeological materials and unique ethnological materials that are first discovered in and subject to export control by the source nation. Restrictions are conditioned on determinations of pillage, self-help, concerted international response, mitigation, and international exchange. Under a plain reading of the CPIA, import restrictions ought to function as a selective filter, fact-specific, focused, and finite. Instead, they've become blanket embargoes on everything old. Worse, the State Department routinely restricts imports of materials that are privately owned and freely traded in countries like Italy and China. States' bias against Americans is unjustifiable. The worst fears of the internationalists have come true. While Congress was enacting an internationalist policy, U.S. criminal law endorsed cultural nationalism. Under the McLean cases, a holder can be liable under U.S. criminal law if he knows that an object was exported in violation of a foreign ownership law. That is the blank check rule that was rejected by the U.S. delegation to UNESCO. In 1985, Senator Moynihan proposed S-605, a bill that would have limited U.S. criminal law to theft from inventory and not by decree. A looting crisis would be addressed by import restrictions under the CPIA and not by general criminal laws. Professor Bator testified in favor of the bill, but State and Justice testified against. Justice stressed the need to preserve the widest scope for enforcement and gave assurances that the burden of proving criminal intent would protect the innocent and prevent prosecutorial abuse. The bill failed. In consequence, two theories can govern the legality of importing the same object, and criminal liability can be triggered by imports that are permitted by the CPIA. This makes no sense. Yet, in the Schultz case, a federal court of appeals declined to resolve the tension between the conflicting theories. Civil forfeiture has become a third theory of liability. Seizure of an object can result in forfeiture and repatriation based on an alleged breach of foreign law without any proof of critical facts, foreign law, or the merits of the claim. Recent examples are the Steinhardt Fiale, the Cambodian statue, and Mongolian dinosaur fossils. The high burden of proof and bar to prosecutorial abuse stressed by Justice at the hearings on 605 have disappeared. The trend is troubling. Jim Fitzpatrick's 1983 article called Customs Policy Wayward and Lawless. The recent trilogy of articles by Andrew Adler and Stephen Urias called it extra legal. The pendulum has swung entirely in favor of cultural nationalism, national retention, restitution, and repatriation. The centrist, internationalist legacy of Moynihan, Bator, and Feldman is dead. Is this where we want to be as a nation? For example, the State Department proposes to return to Iraq Jewish archives confiscated by Saddam's regime. Is that the right thing to do? The AAMD's 1970 rule has made orphans of hundreds of thousands of under-provenanced objects. Should we try to restore legitimacy to these objects by adopting a web-based system of publication and registration? I would not do so unless transparency is rewarded with repose and a fair dispute resolution process. But I leave further discussion for the panelists, and I leave you with three questions. Where does the national interest lie? What should our policy goals be? And what legal theory would best achieve those goals? Thank you very much.
Okay, welcome to our first panel, Cultural Property Implementation Act in U.S. Criminal Law. I'm Jean Schroeder. I'm a professor here at Cardozo. And let me introduce our panelists in alphabetical order. First, we have Andrew Adler, who's an associate at Boies, Schiller, and Flexner in Fort Lauderdale, Florida. He has previously served as a law clerk for judges in the 11th Circuit and the U.S. District Court for the Southern District of Florida. He serves as an adjunct professor at the University of Miami School of Law, where he co-teaches a seminar on cultural property with Professor Steve Urice. And as Will Pearlstein said, he's authored several articles on cultural property, and also co-authoring with Professor Urice on these issues and the conflicts we're going to talk about today. Next, we have Evan Barr. He's a partner at Steptoe's New York office, where he concentrates in white-collar criminal defense and complex regulatory matters. Now, prior to joining the firm, Mr. Barr was chief of the Major Crimes Unit at the U.S. Attorney's Office in the Southern District here in New York. And as a federal prosecutor, Mr. Barr was the lead attorney in the landmark Second Circuit case of, I love these names, United States versus Antique Platter of Gold, sometimes known as the Steinhardt case, which is discussed in the white paper in quite a bit of detail. And he also successfully litigated several other cultural property cases for the government involving civil seizure and forfeiture of an 18th century document from the Mexican National Archives, a Roman marble torso that's stolen from a convent in Naples. What do they have, a marble torso in a convent? Sounds bad. An alabaster plaque looted from museums in Yemen, and on, very impressive. Now, Mr. Barr received the Department of Justice's John Marshall Award of Outstanding Legal Achievement in Asset Forfeiture in connection with his work in recovering and repatriating numerous items of cultural property. Next, we're going in alphabetical order. On my right here is James McAndrew. He joined the firm of Grunfeld, Desiderio, Lebowitz, Silverman, and I should have asked you how to pronounce this, Clistot, as a forensic specialist. He has experience in customs, international trade, and in international sale, acquisition, and transfer of works of art and antiquity. He has more than 27 years as a senior special agent, first with the United States Customs Department and then the Department of Homeland Security. He was designated as the subject matter expert in international art and antiquity investigations, as well as international trade laws and agreements. At Homeland Security, he was primarily responsible for the development and implementation of the department's International Cultural Property Program, as well as its national training program titled Fighting Illicit Traffic in Cultural Property at U.S. Points of Entry, hosted at the Smithsonian. He was an active member of the U.S. Department of State's Cultural Property Task Force and Interpol's Cultural Property Task Force. He ultimately covered, over 2,000 works of art and antiquity for countries around the globe worth tens of millions of dollars. And last but not least, we have Michael McCullough, who is a founding member, and happy to say, of Pearlstein and McCullough, a new law firm, a firm focused on delivering a full range of legal services to its core sectors of art, cultural assets, and international trade. He advises art collectors, galleries, auction houses, museums, online art sellers on the purchase, sale, financing, and international trade of fine arts, the decorative arts, cultural property, and antiques. He is a former associate counsel to Sotheby's Worldwide, where he facilitated the acquisition and sale of some of the greatest artworks in the world. Mr. McCullough also has extensive experience in customs law and international trade matters. He counsels multinational companies on the development and implementation of global policies and procedures related to U.S. regulations. He's a member of the Art Law Committee of the New York City Bar and vice chair of the Art and Cultural Heritage Law Committee of the ABA. Now, the first question I want to ask, of course, we do have the white paper here. Do we really have a problem, and what is it, before we start discussing possible solutions or how should we be dealing with it? So I'm going to start with Evan, since you're one of the heavies in the white paper.
Appreciate that. So I think I've got a fairly balanced outlook on this. I was a prosecutor for 10 years. As you know, I did a lot of these cases, and now I'm actually on the defense side and been representing galleries, collectors, people who are claimants in these forfeiture cases against the government. So I think I've come fairly balanced. And I realize coming here today, I'm sort of balancing, on the one hand, my legacy versus my livelihood. And I'm going to come out in defense, ultimately, of my legacy. I think the white paper, obviously, is a remarkable piece of scholarship, and it was a fascinating read for me. I happen to think it's an overreaction. And I say that because I think that the reality is the apparent inconsistency that Bill sees between the CPIA regime on the one hand and the what I'll call the NSPA set of cases, the McLean, Steinhardt, Schultz line of cases on the other hand, I think is not an inconsistency, but rather an overlap that exists in many areas of regulatory and criminal law here in the U.S. That is, these are alternate remedies. I think it's quite clear from even the Senate report back in 1983 with respect to the CPIA, it was never meant to supplant or preempt the existing body of law, which included the NSPA at that time.
That's the National Stolen Property.
Yeah, sorry, National Stolen Property Act. And when I refer to that, I mean these cases where U.S. courts and U.S. prosecutors are essentially bringing either a forfeiture case or in some rare instances a criminal case based on the fact that an item, an archaeological item, arguably belongs to a foreign country such as Italy, based on that country's patrimony laws, namely that the object was found in the soil of Italy, therefore belongs to the Italians. And if you traffic in it here, you're basically trafficking in stolen property. That body of law, I'm saying, exists alongside of the treaty mechanism, and they are not mutually exclusive. This is something you'll see in my practice. For instance, I do insider trading cases. There's a remedy under Title 15 that deals with schemes to defraud in the context of securities, but federal prosecutors also typically bring in the same case wire fraud or mail fraud charges, and they're allowed to do that, and that's just a reality in our system. Similarly, there's no inconsistency between having forfeiture cases, which have a lower burden of proof, and criminal cases. These will be paired together all the time as parallel proceedings. My other reaction is that I think the alarm bells need not be ringing so loudly because the predicted problem doesn't really exist in the sense that there have not been in 20 or 30 years very many criminal cases, for one. I think you can name them, you could basically count them on one hand. So since 1983, we're all familiar with this, a small handful of criminal cases. I think the prosecutors, for the most part, have exercised discretion in going after those cases that have the most egregious fact patterns, okay? And I have yet to see a criminal case, for instance, where it's in the sort of gray area where, for instance, the defendant really, it could be argued, wasn't quite sure whether the objects that he or she was moving across boundaries, whether those objects were governed by a foreign country's law. The Schultz case, the facts are overwhelming that there's knowledge and intent. Even the Steinhardt case, which is not a criminal case but a forfeiture case, we had a very strong fact pattern of the item being moved in a very suspicious fashion, and there were statements made on the invoice which were highly suspicious. So the idea that federal prosecutors, yes, it's conceivable that you could have federal prosecutors arresting everybody and seizing everything. That has not happened in the 25 or 30 years that we've been dealing with this issue. And finally, I would say that in most of the forfeiture cases, you will see generally another predicate offense, another U.S.-based offense other than the NSPA theory in that forfeiture complaint. In other words, there will be a false statement or a customs importation violation that operates separate from the NSPA theory that Bill is so critical of and thinks needs to be amended. So that also gives me comfort knowing that there's an independent basis, a violation of U.S. law, separate and apart from the violation of foreign law. And I guess the final reaction, and then I'll stop talking, is, we're in a different world. I mean, 1983 is more than 30 years ago, right? And the international cooperation has exploded in that time across the law enforcement. We have much more connectivity in terms of Interpol, their red notices. People are extraditions and are much more common now than they were 30 years ago. So it shouldn't surprise us that Enforcement on this area has also ramped up in terms of countries respecting other countries' requests, treaty requests to seize an item. It's a different world, and to the extent the CPIA has not adequately addressed the problem, federal prosecutors and others have stepped up to fill that void by making creative use of these other statutes.
All right, well, I'm going to want to turn to Andy, but some questions you may want to think about when you answer this. You know, it's exactly right. There obviously are a lot of civil statutes and criminal statutes covering the same behavior. But you gave the example of insider trading law in 10b-5. And essentially, civil insider trading law and criminal insider trading law are the same thing. It's just the degree of scienter for which way we're going to bring the cases. And we usually bring a civil action in addition to a criminal action. We don't always bring a criminal action in addition to a civil action. But one of the allegations in the white paper is here. It's not that we both have a civil remedy and a criminal remedy, but that the underlying statutes and the underlying theory under the two statutes are radically different, which is not what you see in securities law. And that is one of the concerns. And so if you could address that, and also, you know, maybe think fleshing out, this is criminal, but the panel talks about criminal, but you know, what are the sanctions? And, you know, are people going to, did Schultz go to jail, prison?
Yeah.
He did?
Yeah.
But he's not many, you know, but for most people, that's not what we're facing. We're facing forfeiture, right?
Right.
Fines, or, well, if you can address that.
Well, that's a lot of things.
Al?
I think there's two different issues here that it might be helpful to disaggregate. One is, do the laws actually conflict with each other? Is there a conflict here? And if so, what is that conflict? What are those ways in which the laws conflict? And second, if there is a conflict, sorry. I'll speak into the microphone. I think there are two different issues. One is there a conflict in the laws here? And two, if there is that a problem? And I think the second question is a close question, and I think Evan has given a lot of the strong arguments that even if there's a conflict here, it's not that big of a deal. There's been 30 years. There's been a handful, one or two criminal cases that have been brought. There's been more civil forfeiture cases that have been brought. But on the whole, there's really not, the world is not collapsing here. I think there are some arguments on the other side of that. But I think before talking about that, it's first important to understand what are the conflicts we're talking about here. And I think the white paper does a good job of laying these out. And I think does make a compelling case that there are serious conflicts in, on the one hand, the McLean Doctrine and the NSPA, and on the other hand, the Cultural Property Implementation Act on the other hand. And so I thought maybe I'd just briefly explain what some of these conflicts are. They're in the white paper, but let me see if I can summarize these quickly. First, there's a disparity in the definition of the word stolen, really. And this is a critical, I think, conflict. On the one hand, we have in the CPIA, stolen is limited to provenanced objects that come from a specific institution or a site or a museum in a foreign country. So they're documented objects. And that's fairly limited because many of the objects that we're talking about here are not documented objects. Some of them are, but many of them are just found in the ground. They're looted in the hillside somewhere. And those documents are encompassed under the McLean Doctrine, which basically enforces a foreign nation's patrimony law. And those patrimony laws often encompass objects that are not just in a foreign museum, but are found in the ground somewhere. And so it's much broader in scope as far as what it covers.
So, sorry, that was one of the concerns is that usually you would think of civil actions being a lot broader than criminal actions because criminal actions, the penalties are so severe and usually have much higher scienter requirements, et cetera. But in this case, it seems that the civil action is narrower than the criminal action.
I don't think the distinction is between criminal and civil, because what happens here is under the McLean Doctrine, which is interpreting the NSPA, which is a criminal statute, prosecutors can bring a criminal action. But more often what happens is they use an underlying criminal violation of the NSPA to bring a civil forfeiture action on the same theory against the object itself. It's an in rem forfeiture action. It's one of these legal fictions where the defendant is actually the object. So it's not so much a difference between criminal and civil, but as far as the scope of what stolen means between these two statutes. And I think there is a conflict there. I think there's also a conflict as far as, and this is one of the bigger conflicts I think the white paper points out, as far as repose. Is there a period of repose once an object is in this country for a certain period of time? And under the Cultural Property Implementation Act, it sets out this safe harbor. If an object is in this country for X number of years and has been displayed and publicized in museums for a certain period of time, then we're going to say that's off limits. But there is no safe harbor under the National Stolen Property Act. There's a statute of limitations. I think it's 5 years, but because that statute criminalizes possession, it's a continuous crime. So as long as you are possessing an object, there really is no, the statute of limitations is never triggered. So you can be in compliance with the safe harbor of the CCPIA, but at the same time be subject to an action under the NSPA. And so I think that's a conflict, and I think the white paper does a good job to emphasize that. There's also a technical, conflict as far as burdens of proof are concerned in civil forfeiture actions. You can bring a civil forfeiture action under the McLean NSPA line of cases, in which case the government only has to show probable cause to believe that the object is subject to forfeiture. And then the burden is on the claimant to come in and disprove, in other words, that the object is not subject to forfeiture. So it's a lower burden on the government. Under the Implementation Act, on the other hand, the burden is on the government to prove that an object was in fact stolen. So we have a disparity in terms of the burden. It's a little technical, but it's important. And there's other conflicts as well, but these are the kind of things that we're talking about here. So I guess I can stop there.
Okay. So we're next turning to Jim McAndrew, get your view. But one of my questions is, what is Homeland Security involved in this at all?
Well, Homeland Security derived from legacy U.S. Customs, and U.S. Customs, had and has, and now in Homeland Security, the primary jurisdiction of the ports of entry. So Customs law and the Customs Authority that Homeland Security has, it was carried over from U.S. Customs. Borderless Search Authority, that's the big one, of course. And most importantly, to put it into the realm of cultural property, is it's customs because it's an international, industry, that the weak point of the trade is the port of entry. Mm-hmm. What I've heard so far today, and I spoke a couple days ago. I know some of you who've been there heard me say this again. I always like being in this position because this is my experience. This is what I know. I'm not a lawyer. I don't really. What we talked about a lot is McLean, Schultz, criminal, and how there's not that many criminal actions out there. That's right, there's not. But there's thousands of civil actions happening under the radar screen that are more times than not being done administratively. What Customs has, or Homeland Security has, that's different from the judicial process, is the ability to detain and seize anything, let alone cultural property, and the forfeiture process being handled administratively, meaning inside the agency. So a Homeland Security agent or a Customs and Border Protection officer, as we legacy used to know as customs inspectors, uniformed people, could take an enforcement action on at an item arriving at the port of entry doesn't need a search warrant to open it, to take a look inside, can match the object what they see it as compared to what's described on the customs import documentation. And if on their own discretion feel like there's something not correct, it could be an anomaly. They don't need much of anything to detain it. Then they detain it. All of a sudden, the burden already, you can sense, is shifting to the importer as why is there this anomaly. It's a burden of proof. I always say this is battle for the burden. That's my expression. So the importer has to now respond to questions from the customs inspector. Sometimes, and more times than not, the customs inspector's questions are fed to him by the agent, because the customs inspector does not operate unilaterally. He can if he wants to, but he doesn't. He calls the agents up, like when I was the agent, and says, Jim, I have this object. What do you think? Take a picture of it, take a look at it, detain it, and send a picture off to potentially a foreign country what we believe, the agent believes, might be the claimant country. And that starts this trickle-down effect that grossly affects the trade, the people, the U.S. industry in art and antiquities. And of course, you know more times than not, whatever country receives that request is going to make a claim, and now the clock is ticking, the race is on. Can that foreign country establish the provenience or the find spot of the object that's in front of them to establish that in fact that piece existed in situ on this day and was missing the next day? That's a very high level of burden to prove. And I will say, in my experience, 90% of the time, and that's conservative, that source country is not going to be able to establish the provenience of the spot. So let's turn it right back around. This potential claimant country, and remind you, that claimant country might not even be the right country making the claim. The Roman Empire. Michael.
The Roman Empire.
That's the Roman Empire, right. The Roman Empire spanned the whole Mediterranean basin. So what's an Italian? Does Italy have a right to claim it, as an example? Can't Morocco or Spain or anywhere else? So where are you sending this picture to? To all the countries in the Mediterranean basin or not? So you select a country, you leave it up to them to try to establish its provenience, and some to corroborate, to develop some information to make that claim, right? So that's an incredibly Herculean task to ask the source country, although that is their responsibility. So what the foreign countries prefer is to go back to the customs or Homeland Security agent or inspector and say, listen, is there anything on the customs documentation that is not correct? It could even be correct, but it's just vague or merely not correct. Just give me some sense, some minutia to make it a violation of customs law. It takes the burden of proof off the the potential claimant country to prove their case and lays it right in the lap of the importer who acquired the piece, more than likely, honestly, at an auction somewhere in Europe, Asia, South America, from a known source, and now they're cycling backwards. Now they're stuck with the burden. And of course, what's the easy question? When I was the agent, the easy question to ask that importer, all right, no problem. Give me your provenance. Do you have provenance? Okay, pick a country. Italy, 1936, 1932, 1909. They keep throwing dates up. We still in a Cambodia piece, went back to the colonial era dates in the 1800s. not going to get much more long-winded. I think you get an idea where I'm going with this. Is what is Homeland Security's role in here? Is to take the burden. If I want to be frank, is to take the burden of proof off of the potential claimant countries who couldn't probably establish the claim in the first place, and hope and pray that it becomes a customs violation and leave the importers, the people in the trade, from the institutions down to the private collector, scrambling to answer a bunch of questions that, in fact, we all know, for the most part, they can't answer. Thus, you have the seizure. The seizure is accomplished administratively. It never has to go to a former federal prosecutor like Evan Barr. Doesn't have to touch DOJ. And you wish it would, because they're a lot more fairer in their application of the law. Because you have to rely on a customs inspector and a customs agent and a customs lawyer who are all in the same family and the same team. You can kind of get a sense what the outcome's going to be.
Okay, Michael.
Yes.
Well,
Can I just comment on what has been said so far?
That's what I'd hope
Because
to.
I can. Evan said that you could count the number of criminal prosecutions on one hand, I think, and he must have a very big hand or a lot more fingers than we can see. There was one criminal prosecution last year, the case U.S. against Cooley. And the Cooley's attorney wrote a very good memo in the sentencing which sort of summarized all of the criminal prosecutions that have happened in the cultural property arena over the last 20 years. I think there was somewhere between 20 and 30 cases that he cited, of which I think only 2 resulted in jail time. So the overwhelming number of prosecutions resulted in no jail time at all.
Are they settled, or what happens with them?
I think Schultz is the only one that went to trial. Right. Of all the rest of the cases, I think they were all settled. But I think there are more out there than we know. Most of them are smaller. Most of them are, there was a couple of cases of soldiers taking cultural property from Iraq and bringing them back. There were other cases, but I think there was a pretty decent number of cases. There were about 20 or 30 there.
But I mean, are you talking? I'm talking about cases brought under this theory that, based on a foreign country's patrimony law, a criminal prosecution.
Yeah, based on patrimony law.
Okay.
Yeah. Well, again, I guess that gets to Jim's point, and all of our points really. When I work with people who buy and sell art, so I look at this from the sitting in the seat of someone who either has something they want to sell or they want to buy a piece. And when I look at this, there are really 3 main areas to be concerned with. One, as Jim said, the initial issue is importing. If it's coming into the country and you have to import it, what are the standards you have to look at? And the second is, based on the provenance and the knowledge of the piece, do you risk criminal exposure for purchasing the piece in the first place? And then third, as was mentioned, you have the CPIA. So if you're dealing with property that's regulated by the CPIA, then what are the standards there and how do you meet those burdens? So 3 different areas to be concerned with. I think the second one, whether there's criminal exposure, whether this piece of property could be stolen from a foreign country, is the most complicated of the 3. And I think the title of our panel here is the conflict between the CPIA and the U.S. criminal law. I really don't think there is a conflict. I think the conflict is really, how does somebody who wants to purchase an object determine whether it's properly owned, whether the person who's selling it to them actually owns it, or whether is there a foreign government claim here? That is a very complex and very difficult question to answer. In fact, if you look at the Cambodian sculpture case, which was just settled, when you look at the facts of what happened there, you have very smart lawyers at Sotheby's looking at the case and trying to determine, is there a Cambodian government, do they have a claim? And it seems like their answer was no. They looked at the Cambodian law. They determined that there was no issue with importing the piece, and in fact, they imported the object. Now, what seems to happen in between is the U.S. government, along with the Cambodian government, did an investigation, and it sort of reminded me of the movie Seabiscuit. It was about the racehorse. At the beginning of the movie, Charles Howard is the guy who eventually becomes a very wealthy automobile salesman, and he buys that racehorse. But before that, he's a clerk in a bicycle shop. And this newfangled thing called an automobile rolls up in front of his bicycle shop, and the guy gets out, and it's overheating or steaming, and the owner says, "Can you fix my automobile?" And he looks at it, he's never seen one before, and he says, "Sure." And he spends all night fixing, and he figures out the engine, he's a good mechanic, and in the morning the guy comes back and he has it fixed. Well, the Cambodian sculpture case is the same. It seems to me that the US government went to the Cambodians and said, "Do you have an ownership statute?" And they said, "Sure we do." And they went out and found one. And what they found was something in the sort of colonial laws of Indochina that somehow applied to this site or these objects. And that seemed to be the basis of the stolen property claim in the United States. So to me, that the tension really is between the National Stolen Property Act, which is a statute that has no provisions in it about how it applies to these foreign patrimony claims. As I said, I think it's the hardest part because at least the CPIA is a statute that is well-defined. Its intentions are known. How you comply with it is relatively simple to figure out, and you can comply with it. In the case of the National Stolen Property Act, this is court-created law. The courts have created the standards for how the National Stolen Property Act applies to these patrimony laws. And what we really need, where the tension is we actually need that statute to be revised. We need some provisions in that statute to talk about how you apply the National Stolen Property Act to cases where a foreign government is claiming ownership due to an ownership law. Because if, in the Cambodian sculpture case, if really smart lawyers can't figure this out and then have to spend, I don't know how much they spent, maybe $1 million trying to get the piece back and failed, I don't see how anyone else is going to do it.
So, since you're in practice moving along, how are you advising your clients now? Your dealer clients, museum clients, et cetera? When people want to buy?
You fall into two different categories. The first category is people who own, actually there's more than two, but let's go through it. There are people who own objects that they purchased in the past, and they're doing due diligence, and they want to know, do they have any exposure? And that could be across any of the theories we just discussed. That's one category of people. The other category of people are people who are buying things that are overseas and want to bring them in. And those are two very different camps to be in. There are, historical thefts and historical imports, things that have been imported many years ago where there's probably no records of how it was imported. You're in a much different position than something that's been imported recently. If you have an object that you bought 20 or 30 years ago and you're now trying to go back and do diligence and figure out where it came from, how it was imported, you might not find much information, but you're in a much different position of someone who's imported it recently. If you've imported something recently and own it, and you don't have any information about where it came from, well, to quote an old song, no use crying, and praying won't do you no good, because there is going to be a record of that import with customs, and they will trace that back, and there will be an issue. You will have an issue with the piece. Now, there's a third category of people who are the people that Jim was mentioning, who import something and it gets stopped at the border. And that's probably the worst position to be in, because as Jim said, the import laws are very broad. The ability of Customs and Border Protection to detain, seize, and forfeit objects is very, very broad. And like Jim, I have many cases over the last few years, where an object has come in, it doesn't have a long provenance, and the answer from Customs is, well, you've proved to us this is not stolen, or we're going to seize it. And they seize it. And then it goes through an administrative forfeiture proceeding, and unless you're willing to pay, $100,000, $200,000 to start going through that process, there's no use in contesting it. So many of these seizures and forfeitures happen administratively, and they just churn out. They happen, and objects are lost. And unless the object is very valuable, no one is going to pay to go through that process to get it back.
Yes, please do.
That's what I add one comment about the CPIA, which I think when it was written, I think, to the best that it could at the time. But one of the things where what Customs or Homeland Security does is when an object comes in from a country where the country of origin is declared as one of the 14 countries that there's a bilateral with, it says if the object was not imported with the export permit from the country with that has this bilateral, that the importer is allowed to provide quote unquote satisfactory evidence or information. And then it cites in 2 paragraphs exactly what the wording of that satisfactory evidence should state, that it was out of the country before the time of import or 10 years before the date of the imposition of the bilateral. So it shows you what happens with the clients that I have and for them for the firm is you can literally extract that language right out of the law and put it and have your client sign an affidavit or notarized affidavit stating exactly what is requested. So that should have satisfied Customs' concern. It also satisfies the requirements of the CPIA for that purpose. The shipment should be released, right? No. What it doesn't say in the CPIA is it doesn't put limitations on the government, on Customs and Homeland Security to stop asking for more. So you provide that information that satisfies the law, and the inspector or the agent comes back and says, well, I want more. I want another affidavit. I don't like that one. Give me another one. I don't know that person. Give me someone from a different person. And they start concocting or just creating at a whim what they want, and they're continually asking. Now, what happens is, do you feed the government more? If you don't have it, do you try to, or do you not feed them? If you don't feed them more, they're going to seize it. If you feed them more, maybe they're looking for you to create a false statement or take it down the path that you didn't intend it to go, but it starts going. And all of a sudden the case goes from civil to criminal. Now you provided me for. Because don't forget, the government behind the scenes, any document you give them, is sending collateral requests to their agents in foreign countries to verify the document you gave them. And they can catch a false document, a false statement, intentionally or unintentionally, now you got a criminal problem. So there's no limitations on what is quote unquote satisfactory evidence. And again, I have a client right now that's had an object that's detained and seized in April 2011. This is April 2014. I still haven't gotten it released. And so this can go on for another 30 years. Again, there's no limitations on these requests either. And that's what's wrong about the CPIA.
Can I comment?
Yeah.
I want to comment. I want to go back to Mike's comment about, how do you figure out the foreign law question? And let me say, first of all, I hope you'll hire counsel and create more business for all of us. But you also have to obviously contemplate if the piece is significant enough to hire foreign counsel. And in fact, a lot of these cases, of course, end up in a battle of the experts on the particular foreign patrimony law. And there's no question you have linguistic problems and trying to figure out what these laws mean. I'm not suggesting that they're simple. I will suggest a couple of things, though. I mean, first of all, the idea, it's clear since McLean in 1975 that these laws are out there, and nobody can really plausibly argue anymore, oh my God, I had no idea that Egypt had a law. I mean, that's not going to fly anymore. Another thing, just step back and think about this from the other perspective of the rest of the world looking at the United States, okay? We impose very complex legal requirements on people in other countries to understand some of our arcane laws. For instance, OFAC has regulations and trade sanctions against Iran or Cuba or whatever, or North Korea. The IRS, of course, expects Swiss banks to do a lot of its own enforcement work over in Switzerland. Other foreign nationals are prosecuted by the U.S. all the time for violating our complex trade sanctions. I mean, so guess what? We have to get pretty savvy in understanding some of these other countries' rules as well. So, I mean, it's a more complex world for sure.
Right. So what do you advise clients who want to import art? Don't?
Hire very good customs lawyers. No, I mean, look, I think one thing that's certainly true is the marketplace for antiquities that don't have clear documentation has shrunk dramatically. And I think, Jim, you would agree there are very few folks still out there in the business in New York compared to when we started doing these cases. I mean, it has had that impact on the community. But I think the advice obviously is I'll tell you what the best advice is. In terms of a case, if there may be, say, some uncertainty about the foreign law, but in a case like the Cambodian case involving the statue, I mean, you got to stay away from a situation that smells bad. Okay, I mean, this is a case where the piece was chopped off at the legs, and so the feet are still in the ground, and you've got the other part of the statue. I mean, guess what? Bad facts, look out. So I think and frankly, the Steinhardt case was a similar situation. These are not cases where I think purely innocent folks are getting sort of caught up in the intricacies of foreign law. The Steinhardt case, you had the piece was effectively transshipped out of Italy, so that it could be hand carried over into Switzerland and flown out. The invoice, it wasn't a mistake that Switzerland was put down. They clearly understood that it was of Sicilian origin, sophisticated. So, when they're bad facts, you're going to get the authorities interested. If the facts are pretty good on their face, I don't think you're going to have to worry about a claim purely based on a gray area of the law.
You have anything to add?
Well, I might respectfully disagree a little bit on that, because I think on the cases the egregious cases, I don't think anybody's disputing those cases. The Schultz cases, the McLean cases, where they ripped it out of a jungle somewhere and it was, put in a box and went through various countries. But I do think that people are worried about the gray cases, and that's, I think that's the fact that we have to ask this question is a problem for people out there in the real world who want to know what they can do. And when you have an area like transactions and not just art, but in anything, you want to know what the rules are. And when the rules are unclear and there's uncertainty, it's a problem. Transactions are much more unstable. They're subject to disruption, and it's just not a good situation. I don't have as much experience practically dealing with these issues, so I would defer to everybody else on those. But I would say that from my perspective, just as, and I try to tell people that, I'm just sort of a disinterested lawyer who is just looking at these and trying to be as objective as I can about them with no stake in the game here. I think from a legislative perspective, the fact that you can comply with the CPIA and import something lawfully under the CPIA and have that same object subject to action by the federal government, possibly even criminal action. It might be unlikely, but it's certainly possible. That's a problem. Just from the standpoint of having our laws make sense and be coherent. To have two federal statutes addressing the same issue from different perspectives and from that are at odds with each other, that to me is problematic. Now, I worry about that a little more perhaps than Evan does. So,
if I could jump in on that, I agree with you. We have to distinguish between traditional theft cases and these national patrimony laws. If I'm not mistaken, the Schultz case was a theft case. That object was stolen from a museum or from inventory. It was covered up with plastic and then it was taken out of the country, and it seems that both the dealers knew that this was a stolen piece. I'm not going to be mistaken about that, but there have been cases. I guess the St. Louis Museum, the Knefer case is similar. That was a piece that was stolen from museum inventory. Then you have these other cases where the origin is unknown, and the argument is that the nation's law vests title in that object in the foreign country, and therefore the foreign country owns it. Now, in the Cambodian sculpture case, it's an object that was taken from a temple. Well, Many objects are taken from temples. I mean, the fact that we don't know where an object comes from shouldn't make us feel much better about dealing with it. The fact is that all of these objects are taken from a foreign country, whether they're taken, whether the feet are there, still there, or the feet have been taken also. I mean, that's not an important distinction to me. What's important is whether the buyer in the United States or the importer can figure out what those foreign countries' laws are before they import it and rely on the fact that if they have good counsel advising them, that the known laws will be looked at and you can determine whether that foreign country has an ownership claim. And my point is, in the Cambodian sculpture case, you have very good lawyers looking at this, and I think they were right. The Cambodian law is not enforceable in the United States on the National Stolen Property Act. They were right. The problem is the court actually didn't disagree with that. All the court said was that that's a great point, but that's a defense at trial. You have to wait till a trial to raise that defense. You can't raise that now. And the problem I have with that is that you can buy an object, get a very good lawyer to give you an opinion, you can research the foreign law, you can import it, and then you have to go to trial to establish that that foreign law cannot be enforced in the United States. So how much money are you going to spend? $1 million, $2 million to get there? Very few objects can withstand that kind of scrutiny. So my point is that instead of doing that, what the National Stolen Property Act should do is it should be amended to require that there's an evidentiary hearing pre-trial to determine whether that foreign law is enforceable under our National Stolen Property Act. The limitations on the enforcement of that law under the National Stolen Property Act were created in McLean and Schultz. My point is that the judge in the Cambodian sculpture case said there's no case law, none of those cases tell me I have to decide that now. With all due respect, it was probably the right outcome in the case, and there's nothing in the law saying the judge couldn't do it. Now, if we change the law to require that, then if there is a dispute at the time in a pretrial setting, we can determine whether the law applies. And then the fact is that in some of the cases the law will apply and the object could be seized. In some of the cases it won't. But at least we'll know up front instead of having to spend millions of dollars to figure that out. Now, there have been other cases, such as there's a seizure and forfeiture in Miami of an Egyptian sarcophagus cover in 2006, which did not recognize the 1983 Egyptian statute, but went back to 19th century statutes to determine that the object was stolen. So the government doesn't always play by the same rules every time in every case. And I think the Cambodian sculpture case is an example of a piece that should have been imported, that the foreign law is probably not enforceable in the U.S., but they took it anyway.
Okay, well, we're dealing with that. Just to clarify, under the National Stolen Properties Act, I would have thought, because I don't practice, that it would be the government that had the burden of showing that something is stolen and a law applies, rather not a defense. But you're saying.
Yeah, but the threshold is low. I mean, Evan's the expert here, but if you read I brought the cases with you. In both the Cambodian sculpture case and the Tyrannosaurus bataar case, there's a very good discussion in both cases by both judges about what the standards are. And it's complicated. It depends on whether it's a Title 19 or a Title 18 case. Right, Evan?
Yeah.
Do you want to go through the distinction?
The customs-based, the Title 19 customs-based cases, my understanding is the burden of proof, the government bears the burden of proof initially to show that the item is subject to forfeiture. In that case, it's a probable cause standard, which is quite low. Mm-hmm. In a Title 18, which is your traditional U.S. federal criminal code case, which would include the National Stolen Property Act theory, government bears a burden by a preponderance of the evidence. Now, another interesting, which is still not, obviously much less than a criminal case, but we're talking about an object, not somebody's freedom, so it's understandable, right? Mm-hmm. The other interesting thing is one thing to note is there is now, since the year 2000, there is an innocent owner defense built into the forfeiture laws, whether customs or Title 18, which is an important sort of, safe harbor, if you will, so that in the event that a person who brought in an object, the object ends up being forfeited, he or she does have the ability to come forward. Now that claimant bears the burden on this issue, but to come forward and show they did not have reason to believe there was a problem, they're a bona fide purchaser for value, et cetera. If they can meet that threshold, they can still prevail in the litigation.
Prevail in the criminal litigation?
No. This is a civil forfeiture.
Forfeiture.
Yeah.
That was one question I was going to, actually, somebody had asked that precise question, that you have an American goes abroad, buys something, brings it home, and finds out. Now, in American law, bona fide purchasers for value never take free of the claim of an owner. But most other countries do have some sort of good faith purchaser rule where an innocent purchaser does take free. How does that interact here?
Right. So again, in these federal forfeiture cases, if the government's able to meet its burden, the burden then shifts to you, the claimant. Let's say an individual like a Steinhardt, for instance, would argue, I'm a bona fide purchaser. I had no reason to believe this item was subject to forfeiture. And this is a factual determination. You'd have to subject yourself to a deposition. The government would cross-examine you at that proceeding, and there'd be a briefing in front of the district court judge who would then rule up or down on the validity of your innocent owner claim. If you prevail, then you get the forfeiture is vitiated with respect to your interest in the property. Criminal case, totally different. If you have a good faith belief, for instance, based on advice of counsel, that's going to be a damn good defense to any criminal prosecution. So this sort of nightmare scenario that we're talking about, say in the Cambodia scenario, let's say it had been a criminal case. If, in fact, you've gone to distinguished counsel in the U.S. and or abroad and gotten yourself a memorandum interpreting the law, and you think that you're in the clear, that's going to be a very effective advice of counsel defense to any criminal charge. Because in a criminal case, if the feds were to bring such a case, which, as I submit, is extremely rare, if ever, the government bears the burden of proving beyond a reasonable doubt that you acted with malicious intent. So a letter from a fancy law firm is going to be a pretty damn good defense.
Andy, you were...
this is kind of getting technical, but sorry. I might be wrong about this, but my understanding is that, if anybody's curious, the statutes that we're talking about, the general forfeiture statute that applies in most cases is 18 U.S.C. 981 and 983. And in 2000, Congress passed something called the Civil Asset Forfeiture Reform Act. And under that statute, which applies generally, it's in Title 18, which is the criminal code, the government bears the burden to prove by preponderance of the evidence that the object is subject to forfeiture. That's the general sort of default. But there's a provision in that statute which carves out Title 19, cases brought under Title 19, which is the forfeiture or the customs title. So these cases that we're talking about, under Title 19, you can bring a civil forfeiture action. And in that case, there's a provision under Title 19, it's 19 U.S.C. 1595 lowercase a, and it allows the government to bring a civil forfeiture action against stolen property. And this is the statute that prosecutors often use in the cultural property context. Now, if there's a false statement or something else, false statement on a custom form, they go back to Title 18. But there's an independent basis to bring a forfeiture action under Title 19, which doesn't reverse the burden, but in that case, then we have the government. It has a probable cause initial burden, which is very low, and then the burden is on the claimant to come in and prove by preponderance of the evidence that the object is not subject to forfeiture. So it's almost a reversal here. It gets a little more complicated when we start talking about the CPIA. So those are cases where our McLean cases, our NSPA, the underlying theory is based on the National Stolen Property Act, and that's the burden that's going to apply. It's going to be on the claimant, not on the government. Now, if it's a case under the CPIA and we're talking about a site-specific documented object, then there's a kind of an obscure provision in the CPIA. It's 19 U.S.C. 26 10, I think, and it says that in most cases, generally speaking, the Title 19 burden applies, so it's on the claimant. However, we're going to make an exception to that in our case for stolen property, and the government is going to have the burden. So long story short, we have, under the CPIA, we have a burden that's on the government to prove that the property was stolen, and under the NSPA, civil forfeiture cases, the burden is on the claimant after the government meets an initial probable cause burden. I'm sure that was much more technical than anybody wanted to know.
Okay, we're talking about the importing of objects, but the other question that I seem to be raising is, what about museums and collectors who are now in possession? Because one of the things that was very interesting that had been mentioned is that one of the things at first thinking, well, there's a statute of limitations, and so after 5 years you should have clear title, but that the offense is not just acquiring the object, but it's possessing the object. So every day you remain in possession, the statute starts running again, right? So what is the...
I was intrigued by that. I mean, I think the reality is, though, that as far as I have never heard. Let me back up. In the wake of the Steinhardt case, I remember there being concern expressed by one of the amicus briefs to the effect that basically, if the Second Circuit affirms this theory, basically Italy and other countries are going to go attack the collections at the Metropolitan and the Boston Museum of Fine Arts, et cetera, et cetera, et cetera. No one's going to be safe. The museums are going to be emptied out within a few years. Okay, it has not, to my knowledge, happened. I mean, and Mike, you correct me because maybe my counting is off.
I will.
But I don't know of any cases where the feds have gone after an item that's been, sorry, they cut me off. I don't know of any cases that have been brought against an item on the theory that an item that's been in the U.S. for many years and it's just sitting there on the theory of the sort of continuing violation notion. I think I have to believe 99% of the cases, if not 100%, are based on an import as the triggering action. And as you pointed out, it's a 5-year clock that starts ticking from the date of import. That is almost always the jurisdictional hook because typically there's some sort of false statement that's going along with it. And it's the event that in the history and the life of a piece whose provenance is uncertain, it is often the one sort of clear demarcating event, the day that it came in, assuming it wasn't smuggled in somebody's suitcase, but actually was declared. That gives you a clear... So I just don't know of cases where an item's been sitting in the closet at the Met for 25 years. And in fact, interestingly, with the Fiali, the Steinhardt piece, its twin is at the Metropolitan Museum of Art, sitting in a case. You can go see it. And guess what? The feds did not go and confiscate that piece. So anyway.
Yeah, I mean, the St. Louis Museum case, I think, actually bears out exactly what we've been talking about. I mean, that's a piece that was on exhibition for a very long time.
Can you explain the facts?
Yeah. You can't speak about that one, right? Or can you talk about that one?
We do, yeah.
No, you go ahead.
No.
No, you.
Finish.
I'm not even sure you can talk about that.
No.
Okay. Let me do it quickly and I'll give you a chance to respond. In the St. Louis Museum case, the massive Knefer was on exhibition, 20 years, practically. And it seems that there was some contact made by the Egyptian government to a young guy named James McAndrew and someone named Bonnie Gardner at the FBI at the time. I'm not sure Bonnie was at the FBI at the time, but there was some contact made by the Egyptians, and then the case went nowhere. And then later on, the government contacted the museum and said, we are going to bring forfeiture action to take this piece back. And the museum hired some very good lawyers who decided to start a declaratory judgment action in federal court in St. Louis to determine that they had title to the piece. That's a traditional theft case. That was a piece that was stolen from a museum inventory, and it was stolen somewhere in a 5 or 7 year period, probably in the 1950s or 60s, I don't remember. But In that case, the court said, no, I'm sorry, this forfeiture claim can't go forward because there's no specific information about the theft. The fact is that the Egyptians didn't know in this 5 or 7 year period what happened. It was in a museum inventory. It then disappeared, and no one knows how. And the court said, no, that's not enough. There has to be some, if you're claiming that the piece was stolen, then you have to show proof of a theft. So proof means who stole it and when. Now, in the Cambodian sculpture case, the government, nobody knows who stole it and when. The revised complaint mentions that the piece was stolen in a window of time and was distributed through a well-organized looting network in Indochina somewhere. That's a theory, but again, to me, the St. Louis case and the Cambodian sculpture case are the same case. And I think they should have come out the same way, but they didn't. So I think the Islam case is an example of something that can be on exhibition for a very long time, and the government comes back at a later time and says, we want that piece back. That's on appeal now. We'll see where it goes. Sorry, Jim.
Well, I can't talk about the Islam case, so I'm sorry about that. But just one point I'll make on that is Egypt didn't pass the national ownership law until 1983, way after the time frame you're talking about, that there was this gap of time where they kind of didn't have any knowledge of where it was. But the point I want to make that I think, again, I was going to try to fill a gap, I think is really important. I had the good fortune in my career with the government of traveling the world, attending conferences around the world, speaking with countries from around the world. I spent time in Egypt and all the continents for the most part, Lyon, France, and big international conferences, and Interpol, addressing hundreds of nations at a time. And the comment that Evan Barr had passed, that he doesn't see countries coming through, sweeping through all collections and museums and taking everything. That's not by law, in my opinion. That's by choice. They see the countries are selective on what they want to see. That's the experience I've had. They'll look at a collection is publicized. It's online, or it's in a museum. It's in an auction house. It's in the private. It's again online, and they just in some respect is an arbitrary approach. Just experience I've had with them, decide what they want to go after. So it's not like the pieces sitting at the Met and all the museums that people are mentioning aren't at risk. They are at risk. Italy can wake up, or Egypt tomorrow, and decide the piece they passed over 10 years ago, to decide they want now. And they're going to shift the burden back on you. And like Evan had said, like I said earlier, and they're right, they know they're going to have a heck of a time trying to be able to establish that claim. So they're going to rely on the customs people to try to establish how it got into the country, and they're going to look for the anomaly on the import documentation and make it a customs violation. As simple as that. So in theory, all the collections that are out there, all the internet sites, countries, if they had the resources and time, could claim everything and come after everything. They just choose not to. And that's an important. I mean, it goes back to what I do with clients, similar to what Mike does, and perhaps Evan as well, and everybody else up here. Is it comes down to the old cliche risk assessment. On a scale of 1 to 10, let me see your collection. Let me evaluate it. Let's see what provenance you have. Let's see the country of origin. Most importantly, let's see how it was imported into the United States. Because ultimately, I want to get to the customs documentation as much as you do, and as much as the country, a potential claimant country does. And if I, based on my customs experience, recognize that the customs documentation was complete, filled out or completed 100% properly, up goes your increase of comfort. If they look like a mess, put the piece back in the closet. It's as simple as that, and just wait for a rainy day for things to change. But the risk assessment is really critical on even us determining. And what's the cost benefit to the client to allow me to do that? Is because, lo and behold, a lot of people don't want to ask certain questions that I will ask. Because, see, it's a daisy chain. The piece that you own today was owned by someone else, and someone else before that, and someone else before that. So as a government agent, When I come to you and ask you questions about your piece and you give me a response, my question is, this is the beginning. I'm going to subpoena you. You're going to tell me where you got it from. And my subpoenas are going to keep marching their way backwards till I can get to the guy who brought it into the port of entry. And then I want to see what the documents say and see if I have if I can make a customs violation out of this. And back the way things were back in the 80s and 70s when all the scrutiny and demand for provenance and where we are today, they said that things have changed since 1983. No one cared as much about this kind of this documentary requirements and how things are handled and so on and so forth. Now they do. So you guaranteed if I start having to rely on 1970, 1980 documentation, it doesn't give me much more sense of some comfort. But that being said, the farther back you go, the better you get, the better comfort level you get, the lower the risk level happens, and ultimately for the collector, the potential for an increased value in the item because the documentation speaks for itself adds interest to the collector.
Well, we're going to have to wrap up here, and there's a lot of other questions I want to ask. But I just want to, and the subsequent panel is really talking about proposed solutions. But the one thing that Evan said at the beginning that struck me very much reading the white paper, 1983 was 31 years ago now. The CPIA was passed. And this is a very different world. And we seem to, if anything, have a conflict. It would seem to be between the Congress circa 1983 from a Democratic, from a New York senator who had sympathy for the New York arts community. And now we have an executive branch and State Department who's a much more internationalist approach. And there just has been a sea change in governmental attitude, it would sound like. And one thing that's really struck me is that you have more and more of these cases, post 2001,
Certainly.
Homeland Security. So based on that, where are things going if we don't?
Well, continue. I mean, it will continue like this, and I think the goal should be for people who collect museums, auction houses, to get some legislative effort together to clarify what the rules are. The idea of having to go to court and spending, if you're a museum or an auction house, to spend $1 million to figure out whether your client has title, whether you have title to an object, is just an unbearable burden. And I know it doesn't happen every day. I agree with Evan. It doesn't happen every day. But the fact that it can happen is something that scares a lot of people, and it has a chilling effect on the market. And I think it's a good idea that we're paying attention to these issues. I just think the rules are so unclear that a major museum, a major auction house can run afoul of these rules when they're really trying.
Any response?
I would just make one suggestion. Rather than attempt to amend a statute, I think there's a possibility of a dialogue with DOJ as well as Homeland Security, where we could at least suggest. I certainly think the DOJ, before they bring an action like this, should consider certain factors. So this could become part of the policy manual that they have. Now, of course, it's not going to be enforceable. It doesn't create any private right of action. You can't come in and argue it to the judge, that they didn't follow their internal protocols. But my experience with those types of things, memoranda that are issued to prosecutors within the department, for instance, is that they at least get the individual prosecutor thinking through the right issues. So, for instance, I think in these cases, any assistant U.S. attorney should be thinking about, for instance, whether the foreign country that's making the claim enforces the laws back home, whether the claim was brought in a timely fashion, or if they sat on it, is there a good excuse? Is there an independent U.S. Violation? And has there been reciprocity in terms of, because a lot of these cases, by the way, have a diplomatic component that goes beyond the artwork, where we might have an interest in seizing an item for the Mexican government or the Italian government because we have a a reciprocal request pending with them to get somebody extradited or whatever it may be. So I think it would be a good productive step to try to get the Department, Homeland Security, as well as DOJ to at least think through these factors. After that, as you can tell from a lot of my comments, you are trusting in the discretionary judgment of the departments whether they're going to bring a case. I agree with Mr. McAndrew that theoretically there are a lot of cases that could be brought, but the reality is that discretion is exercised.
Okay, thank you very much. I believe our next panel is at 3:15.
Yes, it is.
Okay. So,
Good afternoon. Thank you for coming. This is an unusual panel for two reasons. One, no panel I've ever been on has ever opened on time. So the second reason is it's a wonderful and distinguished group of people we have here with us today. The conversation this afternoon at this panel is all about the Convention on Cultural Property Implementation Act, which I will no longer use in those terms, but only the CPIA, or the Act or the law. A few notes here. We'll have presentations by speakers interspersed by questions from me to start things off, and you're invited to submit questions on cards that you should have with you now. I will also invite the panelists to feel free to ask each other questions and comment on each other's presentations. We'd like to end by long before the 4:30 moment, because this next panel has only an hour to be with us. The Cultural Property Implementation Act, the title of this panel is Neutral Interpretation and Fair Administration. That's a sugar-coated pill. There are lots of aspects of this law that have many implications. 32 years after it was enacted, questions have been asked as to whether it still serves the public benefit. Questions have been asked whether it's, even if the law is a really good, balanced, fair law, does the administration of the law follow the act, and then does it serve the public benefit? There's a question, I suppose, that follows from that as to what is the public benefit. Are we talking about what is the international interest, the national interest of the United States, or the public benefit of Americans and citizens who operate according to U.S. law? And there's another question that may follow, because I've heard it raised from time to time, as to whether, despite all the huge amount of effort that went into the drafting of the UNESCO Convention of 1970 and the act that followed, whether it makes any difference at all. Looting continues. The great sucking sound you hear is, if not in the United States, is in other markets in Asia, the Middle East, China. That's another question, a more philosophical one. I'm pleased to introduce, in a very short manner, the high points of our panelists. All of you have a pamphlet that gives their broader resumes. I just want to note that it's an extraordinarily distinguished group. Professor Roussin is not unknown to the Cardozo community. In fact, she belongs here and teaches here, among other places. She has done exceptional work in her own field of interest, which is Holocaust art and its restitution. Mark Wilson is not unknown to the museum community, and I should add that anybody who served in place for 28 years as a director of a museum must be a paragon.
I have a bulletproof vest.
The museum stories he could tell but will never be able to write must be very interesting indeed. Mark was on a panel that I attended 2 years ago at the Asia Society, and was extraordinarily helpful there in clarifying all of our thoughts as to what museum concerns and interests are. But beyond those two individuals, we have two people who were instrumental in the crafting not only of the UNESCO resolution, but also the Cultural Property Implementation Act itself. Mark Feldman, who led the U.S. delegation to UNESCO, the drafting delegation to UNESCO, and Jim Fitzpatrick, who was a member of the team of people, I imagine, who basically put the act into shape in such a manner that it looks balanced today, however it may have started out. So with those preliminary thoughts, I would like to introduce, having introduced them, I'd like to ask Mark if he might lead. Mark Feldman, that is.
Thank you. I want to say thanks to Kate and to Pamela for having me here and for all of their support. Knowing how, first of all, I'm something of an antiquity in my own right, but I've been asked, because of my participation in the formation of U.S. policy to support international controls on trade in ancient art, through the negotiation of the UNESCO Convention and other measures, and it was my role to present the first two drafts of legislation to Congress, and I testified on it several times, but as our distinguished moderator implied, Jim Fitzpatrick was often on the other side and really had more to do with the final text in 1983 than I did, and he'll speak specifically to some of the limitations on government discretion in that text. But thank you for telling me. I'd be happy to do that. I was asked to present some background that would help people here and the panelists evaluate some of the contentions that are put forth in the white paper. And our distinguished moderator has also suggested that we should address more fundamental questions of where the national interests of the United States lies today. And I will try to do that in a few minutes that have been allotted to me, but anticipating the pressures of time, I did prepare some remarks which CCP and Cardozo, the Law Journal, have graciously posted. So if anybody really wants to know what I think and what the background is and how we got to the point of having this legislation, that's the place to look. I'm going to start with a question that either just raised, where does the U.S. national interest lie? And I want to say that in the old days when I worked in the State Department, and I was at one of these occasions, I had to always preface my remarks by saying, I am not speaking for the department. I can still say that. I haven't been in the department since 1981. The views I give you, though, are not only my personal views, but they're my best effort to represent the views of the United States government as they were acted out in the UNESCO negotiations and in the legislative process in the period of 1969, let's say, to 1981. And I can tell you with confidence that there will be those in the State Department today who are not going to agree with the set of values that we negotiated with the stakeholders and presented to the world at that time. So I still don't speak for the government as I address you today. But on one point, I think there is continuity. I believe then, I believe now that there is an overriding U.S. national interest in cooperating internationally to curb pillage of archaeological sites for the purpose of preserving the common heritage of humankind. And in my view, and here I have a slight disagreement with Bill Pearlstein, the interest that is reflected in this legislation is not just the objects, the preservation of the object, but the preservation of the archaeological record. Now, we also have, in my opinion, and it was reflected in the position of the U.S. government in my time, a strong national interest in international trade and exchange of ancient art for the purpose of education and preservation, and particularly education. And when I go to a museum and I see a cluster of students with or without a professor studying some object imported, usually most often long ago by that institution, I am frankly very excited to see that. And I think that that is an important national interest. However, we decided back in 1970, and we had the support of the stakeholders for the most part at that time, that an interest of that kind in cultural preservation of objects, study of ancient civilizations around the world, is not sustainable if it depends on traffic, and I'll say illicit traffic in looted, plundered art. And so we decided as a government to take a new path, which the government had not done before, to try to negotiate targeted, balanced measures that would try to serve some purpose in deterring pillage. Arthur asked, philosophically, has all this superstructure, domestic and foreign, international, had any consequences, done any good? I'd like to know the answer to that question. I don't know who can provide it, but it would be very good to have an international study, whether under UNESCO or otherwise, to try to determine whether these measures are having some beneficial effect. Anyway, we have these interests, and I just want to comment on one other issue, to go back to Bill Pearlstein's very well-put remarks. Cultural nationalism, in my opinion, and it certainly was the position of the United States government in 1970 through 1981, it is not in our interest to support the desire of other countries to foreclose the export of all of their cultural items to the international community and to the United States. That isn't to deny their sovereign right to control their territory and their heritage any way they want. The question is whether it's in our interest to support export controls by applying U.S. Legal machinery, and the answer is under some circumstances, and in a way that might help control if it contributes to the fight against pillage, and if it preserves the U.S. interest and the international interest in exchange, the movement of art, so that it can be studied around and cultures can be appreciated around the world. I would also say, and this is just a personal comment, that when host countries or source countries adopt a policy of comprehensive control, prohibition if you wish, of exports of all of their cultural property, it works against their international interest in trying to obtain the cooperation of other states in protecting that property from looting. Having said all of that, we went through a process in 1969 and 70 of consultation with all the stakeholders interested, and most of whom are represented in this room, and came up with a package of proposals to take to UNESCO. And I have to say that at the time the United States did not initiate the UNESCO negotiations. It had been going on for some time. We had taken a negative attitude towards it. The draft that was on the table by the Secretariat, based on inputs from governments, called for a comprehensive regime applicable to all cultural property, and it essentially said that every country should have an export license and no products, no cultural objects should move internationally without an export certificate, and every country signatory who would become party to this instrument would have an obligation to enforce the foreign law through import controls. The United States government decided it couldn't support that kind of blank check, and we went with to Paris with a radically modified proposal which emphasized three basic points: the repatriation of objects stolen from museums, shrines, and temples, I will say, documented objects, stolen in the traditional sense. That was number one. The encouragement and to the maximum of governmental power, the encouragement of collecting institutions not to acquire objects without appropriate, foreign objects without appropriate provenance. And we put that on the table as an important part of President Nixon's program, because the museums and the museum associations at that time were moving forward on that process. And our task internationally, since this was already in the draft, was to make sure that the United States government would not be required to apply coercive measures, which we had no legal authority to do at the time. And we succeeded in that in UNESCO. The third thing was to limit the obligation with respect to import controls to archaeological material. And it was expanded by agreement in the process to include ethnographic material. And furthermore, no blank check. Bill Pearlstein is completely right about this. We called for, and the convention, the committee adopted a provision which found its way into the convention that called for a concerted international effort. When a country feels that its patrimony is being jeopardized by such pillage, it can call upon the other states' parties to negotiate measures that would be case-specific. When we came to presenting the legislation to Congress, I frankly made a fatal, and the government adopting my recommendation made a fateful decision to add to the legislation the authority to make bilateral as well as multilateral agreements. I thought that was important because at that time it seemed very unlikely that other countries, our importing countries, would adhere to the agreement. I didn't want it to be a dead letter, and I thought if we were in a multilateral negotiation with the art exporting countries, it would be a disaster for the United States. Well, I'm just about out of time. I'll conclude with one final point. Maybe we can come back to it later. And that is that U.S. national interest also includes the rule of law, the implementation of the statute in accordance with the requirements laid down by Congress.
Thank you, Mark. To ask a question, to what extent do you believe not only the CCPIA but also the UNESCO resolution itself has achieved its intended objective, which is to preserve the archaeological record, as you said, and reduce the level of looting and pillage that goes on, given what we now know today? In fact, has anything occurred that can tell us that that objective has been served?
Well, this is the question I ask. I don't know the answer. I would say that hearing this morning that the measures in place today, which go well beyond what we envision, have affected the U.S. market, one has to think that to the extent the U.S. market is a stimulus for that kind of looting, it may have had some meaningful impact. The issue is it being diverted to other countries? You seem to think it is. I have no experience with it. And you're asking a lawyer a question that I'm not in position at least to answer.
Thank you. Let's move on to Jim Fitzpatrick, the next F on the list. Jim, please proceed if you would. I've asked Jim, if I could, to comment on the 4 determinations required under the Act and compliance issues related to those.
Okay, I'm glad to do that. I guess in this discussion, with apologies to Justice Scalia, I'm an originalist, having been around since the beginning. And maybe my comments are dated, but I think having been involved in the legislative process, I have, at least from that point of view, and then in subsequent years with Gary and Kate, other members of the the Cultural Property Advisory Committee, seen how the statute, by my lights, has gone off track. And I just want to identify 5 quick points and then go back to the criteria. The fundamental element in reaching a decision to move the bill forward was that the United States would not act unilaterally, but would act as in a concerted international effort to respond to a specific problem of looting. That gets an F in terms of its administration. The reality is, after all these years, there's not another country, maybe save Switzerland in some instances, that has joined us in imposing import controls. So the centerpiece, and I'll look at that a bit more, of the political compromise, that we not go forward unilaterally, that we go forward multinationally, has been lost. The second thing is that the whole issue of efficacy of these, the question that Arthur asked, are these restrictions efficacious? And my thought is there's a serious question in terms of efficacy if you deal with the basic economics that you have supply and demand, and the thesis of this law is if you cut demand, you're going to cut supply. If you cut demand, you're going to cut supply. Well, what we see is that many of the nations that are asking us to close our borders to the import of foreign materials are themselves the greatest markets for those very antiquities that are denied the United States. China is a roaring example of that. The Chinese market is the greatest market in the world for Chinese antiquities, and therefore are the greatest impetus for demand for looting. So I think that there's been a serious failure in administration in requiring people that come to us to close their borders to take appropriate self-help procedures. The third thing, and I think that Mark, who deserves an immense amount of credit for the work that he did in the State Department to create a balanced approach toward our position, it was clear, I think, from his comments and what I understood, that you were going to have the embargoes that were created under the 1983 law were going to be specific and particularized to instances of looting. Rather than that, you now have in country after country, virtually their entire cultural history is out of bounds. And what that has meant, if our borders are closed, there's a lateral shift. And I think there's evidence of this, and Bill cited in this extraordinary paper that he did. He cited some examples of closing our market. And if there's not international cooperation, that market simply goes to London or goes to Geneva or goes to Dubai. So you are not shutting off demand if simply you move the market from the United States abroad. Finally, there really has been, and this is a biased statement, but from my point of view, from the very beginning, this law has been administered in essentially a stacked deck situation. You've never had, you have great power in the staff in terms of dealing with this advisory committee, and in the entire history of this committee, you've not had a single staff person, not a single staff person that's come from the museum community or the auction community, the dealer community, that they have been shut out, and the entire expert advice that has come to this committee that is making decisions comes from the archaeological community that has, from their point of view, a very legitimate point of view, but that has not had the balance that we all anticipated. Okay, enough at the outset. Let me quickly tell you, there was a great deal of push and pull in the legislative negotiations over what were the determinations that were the foundational points for action by the Cultural Property Advisory Committee, which was supposed to be a balanced committee, make recommendations, expert recommendations to state, first to the USIA and then later to state, which is another interesting story. The idea was that this expert group considered testimony and then went into secret session and evaluated whether the source country had made the following affirmative showings. First, that the cultural patrimony of the requesting country is in jeopardy from pillage of its archaeological or ethnological sites and materials. There had to be a showing of pillage. Now, one of the early issues that were sorted out in the first Italian procedure, you had a great deal of pillage in the south, but nothing in Etruscan areas or in the north. And there was a question, if you can show pillage in one part of the country, do you embargo the cultural property of the entire country? That has gone wrong, or that's gone the wrong way from the people on my side of the street, the dealers. The second, that the state has taken action, taken measures consistent with protecting its own cultural property, self-help. It's clear that a nation like China has the power to police its own sites. During the Cultural Revolution and after, I think for years and years and years, nothing came out of China. There was no external market. And you might have a situation where Iraq doesn't have the capacity to guard every site south of Baghdad. But in China, in Italy, you have nations with the resources to take adequate self-help measures. The third thing, and this was the key, that the application of import restrictions, two elements, there had to be concerted international effort. Our embargo, if combined with the similar action of other nations, you started with a rejection of unilateralism and an exception of concerted effort. So you had to have a concerted effort, and that had to be efficacious. That embargo had to have a substantial benefit in deterring a serious situation of pillage. If the nation creates an internal market for the very goods they say that can't come to the United States, how can the U.S. embargo be efficacious and really be effective? The fourth thing is that the import restriction is consistent with the general interests of the international community in the free interchange of art. This, at the time of the negotiations, was held up as a billet-doux, a tip your hat to the market. The reality is that this provision has been honored, not even in the breach, but in the disregard, because it is directly orthogonal to the idea of shutting down trade and having a blanket embargo of everything forever. There were two basic theories going forward in the 12 years that I was involved. One that came out of the House was that the United States act unilaterally. And that was rejected in the final decision that Senator Moynihan insisted on, that there be an international concerted response. That was the great failing by my lights in the administration of this law, that there have been contrivances to avoid the requirement that other nations join us in closing the borders. Thank you.
Thank you, Jim. It's been alleged that the CPAC and State Department process has become increasingly obscure over time. I served in CPAC for 2 terms, and it was as open as you could get, with multiple explanations as to what we were doing in public. Today, there's an issue of transparency we simply have, or non-transparency we simply have not seen before. And one former member of CPAC has alleged that state has misled Congress deliberately in not filing reports that it should have in terms of allowing the visibility of dissent by CPAC members. Would you comment on that?
Well, yes, I'll comment. You'd think we were dealing on this Cultural Property Advisory Committee with the future of Western civilization being subject to the threat of germ warfare. The reality is, when the committee started under the aegis of the United States Information Agency, the USIA, and that was done, I am confident, because people were concerned that the State Department might roll over to any foreign request. Oftentimes, the State Department is in the business of saying yes to a foreign nation rather than no. And I think ultimately, authority over this entire process was shifted from USIA, which is Ed Murrow's old United States Information Agency, to state, because Jesse Helms had a fight with USIA, and the whole thing was shifted over to state. Since then, you've had a totally different view in terms of administering this law. In the early days, if you wanted to file a Freedom of Information Act request, you could get all of the internal documents, and you could see what the committee had done. And you were able to comment and criticize, and some of those criticisms had beneficial effects. Sunlight did disinfect. Now you get a piece of 40 pages of the CPAC report, 32 of which are completely blank because they've been excised because they're internal memoranda. This whole concept of secrecy is not befitting of an agency that has as its responsibility, on the one hand, listening seriously to source countries, and on the other hand, listening seriously to U.S. domestic interests. And by my lights, at least, the balance is tipped completely away from U.S. domestic cultural interests.
Thank you. Professor Roussin, perhaps you would.
I want to answer that question immediately. There is no language in the statute that requires them to report to the whole Senate or the whole Congress. They do report to the minority and majority leaders of the House and the Senate. The Senate is informed, but nowhere does it state that the entire Congress has to get a report. I do believe, although I cannot prove it right now, that in the past several years there have been art dealers and dealers in antiquities on CPAC. As I said, I can't prove that right now. The process under CPAC is not totally closed. The public is invited to an open meeting. They must submit some statement, and they are invited to attend an open meeting in Washington. So it is not a completely closed kangaroo court. In my opinion, as an archaeologist, because I am a PhD archaeologist, the legislation has been effective. There will never be a time when we can stop looting. Can we stop theft here in the United States completely? No. We can't stop murder completely either. You will never completely stop looting. But the CPIA has had a strong influence on the decline of looting. Also, no place does it state anywhere that the trade in antiquities within a country should be forbidden. If people in the United States want to deal in non-Indian cultural property, they can do so. The museums can exchange, they can have, I think the answer to part of this is to have temporary exhibitions of long range. That's the deal that has been made with Italy. Italy sends us important objects, and we send them important objects that can be on view for, I think it's 3 to 5 years. Italy once had a law that it could only be 6 months. This has been changed. I think that Italy has done as much as they can to prevent looting. They have probably the best task force, or police force, as it were, in the world to curb looting and to bring looters to trial. In fact, I think we should point out that we protect our own archaeological materials better than most countries. There are numbers of people who have been arrested out west for dealing in looted antiquities of the Indian countries, on Indian lands, or on U.S. lands. That would include all of our national parks and any land determined by the government to be the land owned, as it were, by the government. Recently, there was Indian objects were up for sale in Paris. The French refused to take them off, and so I don't remember which foundations got together and very quietly and very secretly purchased the Native American objects for sale in France and then restituted them to the appropriate Native American tribes. It is working. And the more consciousness of it, nationally and internationally, will continue to improve. We cannot force anybody, any other country, to act as we do. There are not just the United States and Switzerland, but many other countries, and I wanted to get a list, but I didn't have time, have acted to enforce the trade in antiquities within their own countries and internationally. It is working. And I must say that the issue of due diligence should be on the purchaser or on the dealer. The dealer should, before selling any antiquity, do the due diligence of making sure that it has not been looted. And the AAMD, the American Association of Museum Directors, has in fact proposed that all of these measures be taken. However, they've left themselves, and rightly so, a really good loophole. Recognizing that a complete recent ownership history may not be obtainable for all archaeological material and every work of ancient art, the AMD believes that its member museums should have the right to exercise their institutional responsibility to make informed and defensible judgments about the appropriateness of acquiring such an object, if, in their opinion, doing so would satisfy the requirements set forth in the guidelines below, which I'm certainly not going to go through, and meet the highest standards of due diligence and transparency as articulated in the Statement of Principles. I, at the time, congratulated, obviously not personally, Philippe de Montebello when Italy came up with the proof, absolute proof, of works of antiquity that had been looted. Philippe de Montebello didn't wait for Italy to come to him. He went to Italy and forged an agreement that I think is excellent. There's mutual cooperation. That can be done with other countries as well. There is no reason that all antiquities should be permitted in the trade. As an archaeologist, things that are pulled out of the ground without archaeological excavation are orphans in history. We will never know any more about that object than its existence. Therefore, we have lost the information about the context of where it was, how it was used, what other things might have been found with it that the looters threw away because they weren't valuable. Careful and legitimate excavation is necessary. And as I said, we'll never stop looting, never. Do we stop theft here? I mean, it's impossible. But we can try. Knowing that we can't doesn't mean we shouldn't try. And I have another comment about the trade. Why should $1 million object not undergo as much inspection and scrutiny as the purchase of a $500,000 house? You're dealing in very valuable objects which should be scrutinized before they are put out on the market. Thank you.
Thank you very much. Professor Roussin, would you favor expanding the Act to include material of cultural importance, but that is not archaeological and that may enter the modern era, and expanding the Act to include ethnological material that is not of a pre-industrial society? Ensure, broaden the Act to become embracing to the point where all cultural material may, upon the request or demand of another country, be restricted from entry to the United States?
No, not necessarily, but there are objects of cultural importance in other countries that are not, strictly speaking, antiquities. They're old, they're not ancient, and they are in danger of pillage as well. I can cite many of the later objects native to, say, Guatemala or even Mexico, which are now protected.
Thank you. That would bring me to Mark Wilson, who may have views on all of the things that have been said so far, but please proceed.
Thank you. This is very humbling. I'm not an attorney. I won't talk like one. The last time I was in a similar circumstance was a very, very long time ago in a mock trial at Yale Law School, in which I was there because I was not in law school, trying to determine whether the activities at Woodstock were protected under the First Amendment. In any event, let me begin by saying that I agree with much of what has been said. I will disagree with one thing Lucille said, this analysis of the importance of, not the importance of archaeology, but that archaeology does not stand alone. One, in my view, what is not at stake, and no one here says it, is the right of a nation to control its own borders. That's not what is at stake here. But I do think that it's important to understand what are some of the benefits of a nation, our nation, in particular, the American mandate, the benefit of having works of art from other cultures, other times. Because in the end, where I'm coming from is within America, what is important for American culture, and if I'm a lawyer of anything, it's going to be the law of unintended consequences, most of which by nature and definition, are unpredictable. First, I would like to add a few ideas about what do these things, what are these things? What is the American mandate? You know, it's very different. We are not a monoculture. Now, many of the nations around the world are not monocultures, but far more so than we. We are the diaspora of the world in one place. Think about that for a second. We are the diaspora of the world. In one place, we have made a proposition. I was very impressed with the first panel because it was all legal and extremely impressive. We have agreed that principle, as embodied in the law and then implemented through the law in our legal agencies, will trump all other social relationships. That is to say, put bluntly, principle is above blood. By blood, I mean ethnic affinity, tribal affinity, linguistic affinity, all of these affinities, which often organize people and bring great woe to their houses, as we witness in the Middle East currently, in many places, in Sri Lanka, in Thailand, and more recently was justification for Mr. Putin to go on a real estate expedition. It is critical, in my view, to get beyond the notion of these works of art as simply being inspiring, which they are, being emotionally overwhelming. In a country that is the diaspora, it is important to see what the rest of the world has produced at the highest possible level. If you do not have that, it's one of the ways for someone who is different from me to build respect. So I think in the United States, to build respect, not just if I'm a recent immigrant from Asia and I'm doing extremely well and suddenly I find as my ethnic group that I have the highest median income of all groups and everybody else is getting a little envious of me, but rather everyone else who've come from other places in the world, and by the way, my grandparents were poor wetbacks from Europe who had not a sou, didn't speak English either. It was important for them to see what the Chinese have accomplished, or the Thai, or anyone else. I think that's very important to American glue. So that, I think, is a way to look at why we have a stake in this legal battle we're talking about. With respect to CPAC, I have no problem with the law. There's no one who is for pillage. How can you possibly be for pillaging these looted sites? What I do not have a problem with the law. I do not have a problem with the way it's worded. But can it be good government? It may be acceptable law, but I will ask the question, can it be good government not to pay attention to the legislative intent, not to pay attention to the words? There is a big gap between vocabulary and application. And if that does nothing but breed cynicism for the very thing we're trying to protect, law, and in turn, politics and the politics of government have never been such cynicism as we see. And in the end, when the law, there were some really wonderful statements here, when the law cannot give its citizens a predictable basis for the future and how generations will proceed from generation to generation, then you are at sea. And it is a chilling effect on all people in every walk of life. And that is why these things, and more and more and more, that comes to play. One of the issues is moral legitimacy. And today you'll find that there is something that is thought to be trumping the law and the law of regulation of our society. And that is morality and ethics. And you have to be extremely careful. At what point does a source nation undermine its moral legitimacy by disregarding the principles and by pillaging itself? That was the point Jim Patrick made. And there, China is a case in point. It's not just that it's the market. It is the system. It is endemic, chronic, benefits. It is operated by every level, including the highest political and military authorities within that nation. That's a question. I don't know. I don't have an answer to it, but somehow there's something wrong with that and asking me not to participate. Secondly, as for the operation, I think it is almost a kangaroo court. It is, to say stacked deck is very polite. You cannot, it has become completely closed. I was involved very intimately with the MOU with China. very intimately on the other side. Here's what I mean by stacked. If you look at the provision, it says the other nation has to initiate the request. I suppose in the State Department could say, psst, psst, put in a request. In fact, that MOU was initiated by the U.S. State Department and drafted in English first by the U.S. State Department. It was only then and entered into discussion in China with the Chinese Ministry of Foreign Affairs, and its existence as a document caught the Administration for Cultural Heritage by surprise. True. And is this the way, is this what was intended? That's my point. Then you have a system of self-defeating. In China, there are three legal things to own archaeological property. It was out and registered, out prior to 1949 and registered, okay? That's legal, no problem. If it's at 1949, it belongs to the state afterwards, right? That's number two. Number three, you patronize it from abroad. You get it, you buy it from abroad, from Sotheby's or Christie's, or anybody else. So what does this do? You get the system bringing out, the endemic system, bringing these things out, excavating, pillaging. I agree it's pillaging. Bring it out. It gets sometimes quite legally. The paper's legal. The stamp is absolutely legal. Sometimes not. It then gets washed and laundered, ends up properly, having gone through the imports in, let's say, London or Paris. It's sold back to a wealthy Chinese dealer who then brings it back to China, and he can own this property and put it in his museum. That is what's going on. Okay, so much for that. Now, with respect to the argument of archaeology, that only archaeology can contribute to the knowledge of these pieces, is simply not true. Archaeology in any object found is subject to the accumulation of several hundred years of knowledge about those objects. So that when an object is found in the earth, it also belongs to a class of objects that are already out of the earth, both provenanced and unprovenanced. A Greek pot. I'm just going to pick a Greek pot. Let's pick the Euphroneous crater, for example. It was illegally exploited. That's absolutely true. But let's suppose what I would argue that, in fact, the Euphroneous crater would have informed the site. The site will not tell us that it was Euphroneous. It says that on it. Nor is that site capable of telling us what the stories are. The site is not going to tell you that you've got Ajax or Achilles or Sarpedon or whoever it was. It's not going to tell you that. The site's not going to tell you what to call it. My point is that archaeology and other kinds of historical knowledge go together. They're not separable.
That's one question.
Okay? It's part of a whole. Many of us are historians, and nor is archaeology necessarily more scientific. I'm an art historian. I use electron microscopes. I use carbon-14. I use all these devices. I use archaeology. Archaeology in and of itself is not the only way to know about the past, even for an archaeological item. And if I discover something by the Berlin painter, I'm just using Greek pots because it's so topical. But you can use other things. Sometimes what I've said applies. It doesn't always apply either. You say that. That's enough. So I'm worried about ultimately where is the glue in this society as we go forward, and the importance of these objects, and the fact that later we'll get into a panel that we are dissolving the traditional bonds of support for museums and what's going to happen there. That's another part of this topic. But it bothers me a lot when I see this dysfunctional government in Washington, one part not paying attention to the other. I just don't see how you can have a government that functions. You do that.
Thank you. Mark, if I may ask a question.
Mm-hmm.
It's the view of a number of people that the array of laws and self-regulation and self-administration that we have in place, including the CCPIA, including the National Stolen Property Act, including the self-rule of the AAMD, has done a great deal to delegitimize private ownership of all categories of art, not just antiquities. There's a darkening horizon that many collectors feel, and museums, I should add, feel that somehow something has gone wrong. It's off the track, and we've done it to ourselves. We've shot ourselves in the foot. Could you comment on that?
Yeah. Let me add one thing. Lucille, I agree with you. It's had an effect, and it has had a positive effect. I don't think there's any doubt about it. I think Schultz has. I think CPAC has too. But I really object to that the misapplication of the law. With respect to your questioning, it comes back to something that's a bigger matter of American society. And is something that's grown over the last generation, bit by bit by bit. Many of these great sea changes aren't a sea change, but a tide coming in very slowly and very inexorably. And it has to do with the notion of commodification of art and the notion that these things are commercialized and that somehow works of art, the euphonious greater, are products of the human spirit that should not be, that are tainted if they are associated with money, and that being the work of art that is in a market and is subject to value, market value, somehow destroys the purity of the human soul that is somehow in its manufacture. The only thing I can say is get over it, because art and commerce throughout human society, as far as it goes back, have always gone together, always. And this is true today. And I would like to offer to you the proposition that the Romans were the greatest collectors of all time. And the things being dug up in a dig were products of themselves of commerce, were they not? I mean, somebody paid to have the euphonious crater made. Then that was found in an Etruscan tomb, presumably, and somehow it got from Attica. Was that a raid? Was that commerce? Whatever it was in that tomb because it meant a lot and it was valuable. So I think you've just got to get over the notion of this commodification. I think that's the underlying moral. It's become a moral issue of the darkening, the owning of works of art that somehow is an individual should not own works of art because they, quote unquote, belong to us all. They represent the untamable, unbounded human spirit. And I think that's baloney.
Mark, thank you. I'd like to open up the panel, ask the panel if any of its members would like to query or clarify any point with respect to any comments that have been made so far.
May I? Mark Wilson, I never ever said that archaeology is the only way to know society.
I know you didn't, but your colleagues do.
No, they don't. And I am, still a member of that tribe, as I am a member of the legal tribe. I'm one of the, I think there are only 30 of us in this country who have PhDs in art history and archaeology and law degrees. I never said that was the only way. These things have aesthetic values, yes, but their aesthetic value would be enhanced if we knew the context in which it was used.
You may know more about it, but that's not guaranteed. A lot of this is predicated on the unpredictability of what's in the hole. You don't know until you open it up.
Absolutely.
And there is, am I going to find, oh my God, eureka, it's going to change my whole idea of the civilization? Or, if you want to, or are you going to find another fragment of an oil lamp of the sort that you used to buy through the New Yorker, for $10? There's a little ad, one of those little bitty ads in the New Yorker. You used to buy an oil lamp. Say, guaranteed Roman Corinthian lamp. And say, how could it be $10? Well, yeah. And I think there's another issue, too, is that we're fighting over everything is the same. A hangnail gets the same kind of legal treatment as a heart attack. That is to say, heart attack being something that was grand, glorious thing that the Getty bought and shouldn't have bought. But, the hangnail is my Roman oil lamp.
Thank you. I think
I pick up on just that hangnail point. What What the statute says that you can embargo goods that are culturally significant. And that concept under this committee's, the staff's leadership has morphed from culturally significant into archaeologically significant. And as Bill points out, those are two quite different views of what's going on. You can have one interesting thing about archaeology and situs. I tell my students, does one really know a lot more about the Rosetta Stone and its meaning, whether it came out of this trench that the French found when they were next to the Nile, or came out of that trench? I would suggest that there's an immense amount of information, historical information, that can come from the surface of a vase, telling you about ancient Greek society or ancient Roman society. One thing that this debate unfortunately engenders is extreme positions on both sides, and that doesn't help thoughtful resolution of issues. I tell my students here, there are no angels and there are no archangels and no devils in this debate. There are good arguments on both sides, and what one needs is to back away from categorical judgments and look as best you can at facts and not emotion. And I must say, people on my side of the street are sometimes guilty of extreme statements, and I think people on the archaeologist side are as well. But that's something that needs to be guarded against to enhance a rational, realistic debate.
Thank you. Mark Feldman, you had a question or point.
A brief comment on the earlier panel where there was an issue whether there is a conflict between the implementing legislation for the UNESCO Convention.
Yeah, speak into the microphone.
Whether there's a conflict between the UNESCO Convention scheme and the National Stolen Property Act. I think, in my view, the interpretation fostered originally by a prosecutor and adopted by the courts, that national patrimony laws convey a title that is enforceable in a penal context in the United States, is fundamentally different, not prohibited by the CCPIA. And I'll leave it to Jim to answer for the legislative history on that measure, but fundamentally inconsistent with the policy judgment made by the U.S. government that lays behind the convention and that statute. And together with the State Department's administration of the statute, which, contrary to the representations made in writing to the Congress, involve comprehensive import controls on archaeology when a request is made, and the customs enforcement of a criminal theory which didn't exist when we were doing this negotiation and which would have changed the entire conversation domestically and internationally. We are no longer, I mean, here I have to say the basic conclusion of the Pearlstein paper is that the balance that was in place in 1970 has been superseded by a new balance, a new regime, which is loaded with a different set of values, which in effect has the potential at least of providing a blank check to any country who wants to do a national patrimony law. That's a fact in my opinion. The issue is it the right way to go? And who should make that decision? I think that decision, as a professor of constitutional law, the decision should be made by the Congress. It hasn't been made by the Congress. Whether you can get the Congress to address it is quite another matter.
Thank you. Are there any other questions on this side? Let's go ahead. Mark.
This is also going back to this first session. There's an assumption that the claimant, and the representatives of the claimant, presumably in the Department of Ministry of Culture or Ministry of Foreign Affairs, are telling the truth, that the claim is valid and that they are not lying. In my experience, there is a great deal of fabrication. And you get caught on the other end. So this gets back to the question of burden of proof. And while there were some very good points, well, you need to show that something is been actually removed. As these have been enacted, cultural CPIA, those are not targeted specifically. In fact, as they are written, they are open-ended and completely broad. They cover anything made, is the way they've been written. Every bit of material culture is covered. And there is no burden of proof, except what Jim was talking about, basically going around to customs issues. And the fabrication at the other side has, to me, undermined the difficulty, made it extremely difficult. I have no problem with the laws. I have no problem with such, except how do you deal with this question of proof?
Thank you. We have only a few minutes left, and I'm going to take the stand and simply ask the last question, if I may. Forgive me. And this is to Mark Feldman, as a former State Department officer, to another former State Department officer. If state has gone off the rails, how do you fix it?
Well, the first thing is to have a dialogue, is to find out whether state has gone off the rails. I tried to have, through an ABA committee, a review of the procedural, not the substantive aspects of the State Department's administration of the statute, and that was blocked by the archaeological constituency in the committee. Unless you can get some independent body with more authority, for example, a committee of Congress, to get the State Department to tell you what they're doing, it will be very hard to make a definitive judgment on whether they are complying with the statute. But given the way Jim succeeded in having the statute drafted, on the face of it, it is very hard for me to understand how there could have been a finding made in good faith that there was a concerted international effort anywhere. From the very beginning of it was more difficult, frankly, in the beginning than it is now under the statute.
Could I just mention, in terms of next steps, one thing that has to happen is that the coalition that Ashton Hawkins led for the museum community and others were involved has to be reconstituted. The museum community, unfortunately, since you were there when we were fighting to hold off China, and you made you made a powerful and impassioned statement as you have today. The museum community has largely left the field, and they are now, this is opinion, they are now largely looking in exchange for an embargo, what's the quantum of loans? And from my point of view, to have an effective cultural community response, the museums are an essential element in any public presentation. So any reform, from my view, having dealt with the Congress and dealt with administrative agencies for a long time, they have the highest element of respect in terms of the way Congress would respond. And I think to get state back on track, if I'm right in my assumption that they're off track, there has to be a way to enlist the museum community once again as a central figure in any reform efforts.
Thanks, Jim, and thanks for the panel. I appreciate it very much.
This, as you know, is the last of 3 sessions, the last of 3 panels. After the third panel, namely at 5:30, there's a reception outside, so I hope the energy that's still and perhaps even building in the room will convey out to the wine table or beer table or whatever it is. I hope also toward the end of our session that there'll be an opportunity for you to get part of this conversation. So if you've wondered why people walk around with those little cards, it's so that you can write something on those little cards, and those little cards will come up here eventually, and you'll have something to say to the panel. So hold me accountable for a little bit of time at the end for that to happen. I started my life, I'm Gary Beacon. For nearly 20 years, I was director of the Walters Art Museum in Baltimore. But I started my cultural property life on a trial in Indianapolis in 1989, the Autocephalous Church of Cyprus versus Peg Goldberg. I was expert witness for the plaintiff. And I think I earned my archaeological gold ribbon for that, and I was put on the Cultural Property Advisory Committee. And I learned what Mr. Fitzgerald, Jim, spoke about half hour ago to be true. I was on with Kate Fitzgibbon as well, to whom we owe this day, really, because she put this session together. Kate, thank you. But I learned also the first time I entered those rooms, and there were 6 of us, there should have been 11, but 6 was enough to make a decision on accepting a pile of papers from Bolivia that was nearly 6 inches thick and included objects of an ethnographic nature whose street value was under $30. So I realized there was something wrong. Dealers at that point were totally excluded from the conversation. They could not be at the table. The original legislation does the right work, bringing potentially conflicting and certainly contrasting voices to the table. But the CPAC I experienced for 3 years didn't achieve anything close to that. I'm on the Committee for Cultural Policy precisely because the voice of museums, collectors, and through them dealers needs to be at the table, and it needs to be heard. And right now it's not at the table, and it's not being heard. This particular session is devoted to the topic of the relationship between museums and collectors, and by extension dealers, in the aftermath of the adoption in 2008 by the AEMD, the Association of Art Museum Directors, of a policy that says, quote unquote, normally museums should not acquire works of art, antiquities, that don't have clear provenance traceable back to 1970. And my question is for the panel, and I hope they address them all. The moving parts on this are obviously the AMD, museums, collectors, dealers, supply countries, because it was hoped when this policy was adopted that supply countries would respect 1970 over their own wealth in the ground laws. And obviously all of this is meaningful only insofar as it bears on the public interest. That's the boundary that connects museums to their value and to the world at large. My own impression was that 1970 was adopted by the museum community first and foremost for public relations purposes. We were in a position of great embarrassment. 2, we took a moral high ground, but 3, we forgot about the law. And I think that's all pretty explicit in the cover paper to the guidelines. They are only guidelines. And if you follow the storyline of these guidelines very carefully, you may know that there's a registry where works of art that are acquired that don't have provenance clearly back to 1970 can be listed. There are something in excess of 500 objects on this registry, and the Walters Art Museum accounts for 60% of them. So that gives you, I think, a sense of where I stand on the matter. But let's start with the questions. What happened? It's been 6 years. What happened? Are there problems? Are there any problems? Are there any benefits that are identifiable from the AMD having adopted 1970 as a bright line? And if there are problems, are there any solutions to those problems? So you could almost imagine, and there are several of us, actually several current museum directors in the room, that we as a panel and you as a group through this conversation are lending your voices of advice to the next steps, because I am absolutely certain that this storyline is not over within the governance walls of the AEMD. So toward that end, I'm going to call on Ron Spencer, who I met at the Brooklyn Museum on a hot afternoon in the spring when they were having a flower festival, and we were talking to an audience of 6, about authenticity issues. And I totally forgot that I'd met him until about an hour and a half ago when he reminded me. But I did remember it was a very impressive paper, whatever the hell it was about. So. Take it away.
Thank you. Thank you. Yeah, I happen to have in front of me something you guys maybe have as well. If certainly you've read them, they may not have them in front of you, and that is the final adopted AAMD membership guidelines, January 29, 2013. The thing that first caught my eye about these guidelines was that in 2 places on page 1 and 2, they say that, referring to the 2008 guidelines, that this analysis, namely the 2013 guidelines, as they amended 2008 and 2004 guidelines, this analysis is not necessarily required by applicable law. No footnote. I wondered what they had in mind. The next page of that same document, the 2013 guideline, says, AAMD continues to encourage its members to pursue voluntary standards for acquisitions that are stricter than the requirements of applicable law. That's pages 1 and 2. In both cases, no footnoting, no reasons given for that. And I wondered, what's going on here? We have a Congress that passed laws. We have an executives who administer the laws. And yet the AAMD decided that they were going to do something that goes beyond the laws. Well, they're entitled to do that, I suppose, on a vote of their members, but they're also, seems to me, they owe the art world and community an explanation of why they did it. So this is by way of addressing the good question that James Fitzpatrick asked, or rather stated, which I think is my observation as well, is that the museums have largely left the field. Now that's astonishing. It's shocking. It shouldn't be that way. Whatever your views on this legislation and its enforcement. So why did the museums, if that's so, and I think at least this man's opinion agree with that, why did they leave the field? I'm sure a lot of you think, as I do, that the Fred Schultz case scared the bejesus out of them. All right? 2002, they couldn't imagine that somebody would go to jail. All right? And all of a sudden, Fred Schultz went to jail. I think he got 3 years. And I think he served most of the 3 years. All right? That was in 2002. Don't forget, these guidelines came in 2004, were amended in 2008, and amended again in 2013. So I then went and looked at the Cultural Property Implementation Act. It's always, I found it as a lawyer, it's always helpful to look at the statute to start with, as opposed to what the judges said the statute meant. And the statute has something called safe harbors. Doesn't identify them as safe harbors, but in Section 2611 of the Cultural Property Implementation Act, passed, as you know, in 1983, there are numerous safe harbors. And I said to myself, well, why don't the guidelines of the AAMD reference even indirectly these safe harbors? I understand all this stuff about the Stolen Property Act passed to protect the interstate transport of stolen vehicles in 1942. And I understand it's the law, and I understand that it's not, that the Cultural Property Implementation Act, unfortunately, is not exclusive, like the Federal Copyright Act is exclusive. And by the way, if we could have one piece of legislation to solve these problems we've been discussing, we ought to get Congress to make the Implementation Act the exclusive law that applies to these kinds of pieces of property. We're not going to get that because the Department of Justice opposed it back in '83, and a large part of the art community also opposed it. So we're not going to get that. But the National Stolen Property Act should not be allowed to gag the museum community. The safe harbor rules. If the property has been held by a museum for 3 consecutive years, and the museum purchased that property in good faith, and then that same museum did one of 3 things: it either published the material that it bought and held for 3 years, or it exhibited the material, or it cataloged the material and made its cataloging available to the public for 2 years. It's out of the Act. Again, we're not talking National Stolen Property Act. It is not dealt with. It's excluded from the 1983 Act. Now, suppose the museum doesn't own it. Suppose there's another safe harbor. For those of you who would like to read, it's subparagraph B as in boy. All right? And it says, another safe harbor, in effect, is that the property has been, we're talking cultural property, of course, the property covered by the 1983 Act, if it's not in a museum, but it's been in the U.S. for 10 years, anywhere, in somebody's collection, under the bed, wherever. And then it is exhibited by a museum, not owned by the museum, exhibited by the museum, for 5 years, out of the Act. Safe harbor. Safe harbor. And if none of those safe harbors apply, the final safe harbor is subsection D as in duck. And it says, if the property has been in the country for 20 years, which today would put us back into since 1994, right? Not a very long time ago. It is also outside of the Act, right? I'm not the only one who's looked at these safe harbor rules. Why didn't the museums look at them? And if they did, what did they say when they were talking about amending the AAMD guidelines? This seems to me proof positive of Mr. Fitzpatrick's point that the museums have left the field. I'm not the only one who can read safe harbor rules. Okay, I think that I know some museums, like the Walters, probably like the Met, apply those guidelines with a common sense approach to the guidelines and use their own judgment based upon the facts and circumstances, just the way the guidelines expressly state they should. But I also suspect a lot of other museums and museum people look at those guidelines and say, we are not allowed to take by acquisition, gift, purchase, or otherwise, we are not allowed to take cultural property unless we can trace it back to its source, its find spot, and how it got into this country. That's not what the guidelines say, but it's certainly a safer way from their point of view to approach this if they don't want to get into a Fred Schultz situation. And it's certainly a safer way for those same museums to cut deals with the source countries to get exhibitions.
Mark, did Schultz scare the bejesus out of you?
Do you want true confessions? True confession. I was there, okay? By there, I mean I was part of the drafting committee. I was in the room for several years. The drafting committee consisted of the representatives of the large American museums who had a stake in antiquities, that is to say, those who had collections. So you naturally found Boston, Met, Kansas City has a big collection, okay, but Chicago doesn't, for example, and across the board. And they were representatives either by the directors or by legal counsel or both. So there were not more than a dozen people meeting, and we were meeting at about the time Schultz was going down. Schultz did not scare it. Schultz may have played into some of our minds, but that was not the principal motivation behind the adoption of these, nor was that the principal how it led to this. So this is a self-adopted, self-imposed, ethical statement. That's why you see the hedges in here, clearly saying that this is not legal. You do not have to require it. Your board, and it's also a bit, into my mind, you have a conflict here between the AAMD as a professional organization and the boards of trustees who are locus in different states of this country and have different responsibilities. They are the ones ultimately who are legally responsible, are they not? Okay. What was behind this? First of all, there was a good self-interest. That it is not good for the museums to be part of an industry and to be part of the pillaging. This was simply an ethical matter. What drove 1970? Why 1970? Ultimately, it is, and I'll get to it in a sec, it's arbitrary. Why 1970? Well, it is the date of the adoption of the UNESCO Treaty. I argued, well, if you're going to have the word used around the table for 2, 3, 4 years, and all these meetings took place in New York, by the way. They were not part of the annual meetings of the AAMD at all. They were these 12 museum representatives, basically meeting up on the, where the floor at the Met is that has the private dining room. Yeah, all that little meeting room, that's where they all took place, and with very nice sandwiches. I argued 83 because that coincides with U.S. law. Why not make, if you're going to adopt a bright line, if either of those, they're equally arbitrary, in fact, aren't they? One is the UNESCO Convention, the other is the adoption of the CPIA. What drove the 70 as opposed to 83 was the desire to satisfy the pressure from European colleagues, European archaeologists, some Europeans in the museum world. That's what drove that. It wasn't anything. It was really nothing else. The major pressure came from the AIA, and the pounding that museums in general, perfectly innocent, most of them, were being whitewashed and taking thanks to the misbehavior, and I'm going to call it misbehavior, I'll probably get hell for it, misbehavior that was going on at the Getty. They shouldn't have done that. I'm sorry. It's not very bright. It's also wrong. So we were all being whitewashed and tarred and unfairly by a press who seemed to have, and may still have, I don't know, an unlimited appetite for sensationalism and mayhem. Nothing sells papers better than loot and stolen stuff. So it was ethical. It was not wanting to participate. And it was felt that a bright line was needed instead of a rolling line. What came out was later tightened up the loopholes that were, again, ethical. To this day, it is still the trustees who are responsible. And the only thing the AAMD can do is censure you as a professional organization should you violate their guidelines. So that is how this came about. There is, however, something at work here that needs to be taken. This is the law of unintended consequences, in which I'm a student, having been the victim so much. It was not foreseen And this is, to me, great insensitivity because it was pointed out to the members that were around the table in the greater membership. The law of unintended consequence, what this would do to the, well, it was intended, of course, to crimp the market, and it did. I mean, the market has shrunk, as we've heard earlier. The number of dealers declined. Museums, if they want to buy a work of art prior to 1970, that has driven the market of those that are verifiable, they pass the test, way, 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 way up, and driven the market, generally speaking, abroad. The market in the U.S. for this material is declining very, very rapidly. You're no longer a player, and New York is no longer a player in the big money in this area and many others. I'm sorry, guys, it's not coming to the Big Apple. That's what's happening. The law of unintended consequences is dissolving the relationship that founded and built the amazing American museum system for the benefit of this great nation and all the different peoples who've come to the world. And many of our museums, if you look at them, Met is the cardinal example, my own museum in Kansas City, which is much smaller. And my philosophy in building the museum was to buy those works of art, all legal, from cultures and civilization that have participated in the formation of modern American culture. And it's that back to that learning of the right of the American people to respect one another, to appreciate one another. The law of unintended consequences breaks not only the relationship that was there with dealers, you may say that's inconsequential, but what it does is it breaks the bond between the people who founded these museums, including the Met, collectors, and who over the years have been their most important advocates. The collectors are now rejected by the museums. That was failed to be seen in 04. Led to 08, because what? A lot of trustees and a lot of boardrooms in Kansas City, in Texas, California, in Washington, in Minnesota said, you mean you have excluded my gift? I'm on your board. They alienated a huge number of board members, and that's why you see the scramble then to correct what is sometimes called an orphan problem.
May I jump in here?
Yeah.
So a problem.
Yes.
A disjuncture between the traditional relationship.
Between the traditional symbiotic relationship between collectors who provided collections. If you look at the Met and the Nelson in Kansas City, everything in those museums is a gift from somebody. They either gave the money to buy it or they gave the thing. And they give money for the endowment to keep it open so that the charge isn't more than the obscene charge it already is.
Excellent. Well, Bill, Saints Bill, that Bill, has addressed this issue. So that's why we're here, is to squeeze, to get in the driver's seat of this 98-page thing and squeal the tires a little bit. So that gets us to the registry notion. And Jen Kretter, whose CV includes all kinds of God work activity, from Holocaust assets to nuns in El Salvador. What do you think?
Well, I actually think a fair amount of my resume is an application to hell. I think I'm probably going. But that being said, I have written about the use of registries for art and to use it as a mechanism to clear title, which I think would benefit, which I think comes with a lot of benefits, both for claimants as well as collectors, dealers, and museums. Transparency is the key to all of this. Now, we've been talking about the effectiveness of the AAMD 1970 rule, and Gary, I differ from your perspective on it a little bit. You said that the museums took the moral high ground and it was only about morality and ethics. And I'm actually relatively happy with the progress in AAMD. But I wrote a paper that's outside, and it's called The Revolution in Museum Ethics, and it traces the change in the AAMD guidelines through 2008. And what you see clearly is a pattern of the guidelines becoming more legalistic. So the law is driving the change in AAMD. I don't think it's just about ethics and morality. It definitely is the law. So a lot of people are in this room are unhappy with the law, and other people have said it's working, it's great. If if I were to point out what I think is a problem in the law, it would probably be that subsection D as in dog that you mentioned on the last page of the Convention on Cultural Property, the Cultural Property Implementation Act, that something simply being in the country for 20 years is a sufficient safe harbor, and I don't think it was sufficient. And I don't disagree that perhaps the understandings of people who were involved in 1969 and 1970, and then again through 1983, with drafting UNESCO and the Cultural Property Implementation Act, it's not that I think that maybe there's not a change that has occurred over time in terms of the executive branch's policies in this area, but I think the idea that the collector-dealer side of this and the museum side in particular is somehow being rolled over, I think is false. And I think that the introduction this year of oops, what did I do with it here? We've got the House Bill 4292. This is jurisdictional immunity for certain art exhibition activities. There's plenty of power represented in Congress, and I believe through CPAC, although I don't have personal experience on CPAC, of that side of the debate being represented. There's simply been a change that's occurred, and change is normal. We have a common law system. Change is part of that system. So what you're seeing happening under the National Stolen Property Act is pouring new wine into old bottles. I mean, that's what happens. And initially, when Portrait of Wally was seized, I even had some concerns. It was the first time that I really had looked in depth at the civil forfeiture issue. And I have concerns about governmental overreaching and having sufficient due process protections for people whose property is seized. But I think that the risks, or the characterization, I should say, in the white paper of people losing all of their property interests in all of these orphaned objects is exaggerated. I understand that plenty of people are disappointed because they had hoped that they would donate certain things, but I don't think they've been deprived of property rights. I happen to teach property. It's one of the courses I teach as a law professor. And one of the things that the students learn on day one or week one is that property rights exist to the extent that the government recognizes property rights. I mean, that's what characterizes the entire bundle of sticks that lawyers always refer to as what is in property rights. Now, in terms of that changing over time, that happens all the time. Think of zoning ordinances going into place, and all of a sudden people can't do with their property what they had hoped to do. Their investment-backed expectations may not pan out to be as good as they had hoped this investment might be. That happens. If I think about what was not legal one day, or legal one day, not legal another day, and then legal again, I think about prohibition, right? So, and here we are with marijuana being legalized. I mean, things change, and that's a normal part of the system. I don't think anything about what is happening right now in terms of the reported cases, I can't speak as to the quiet administrative cases. But anything that I've read in any of the reported cases, be they civil, be they criminal, be they civil forfeiture, I don't see anything extra legal in any of them. I actually think when it comes to the criminal cases, what I see coming out of them seems like a pretty reasonable use of prosecutorial discretion, and that's something that in the past I'm not always entirely comfortable with as being a sufficient protection of people's due process rights and property. For example, under the theft of major artwork statute, it is a crime to simply possess. The statute doesn't say that, but when you read between the lines, there's no room left for anything else when somebody possesses stolen property. The National Stolen Property Act is triggered by a movement across the state line. Traditionally, that's what triggers the modern statute of limitations. So we do have a statute on the books that goes quite far, called the Theft of Major Artwork Statute, and much further than what we're talking about today. And the National Stolen Property Act and customs seizures, those all predate the Cultural Property Implementation Act. They all predate UNESCO, and they are old tools, and it's simply old bottles of new wine. In terms of the database being recommended, what I've recommended in an article that I know the white paper cites to and discusses a little bit, the white paper pushes that much further than I would. I think a database can only work for uniquely identifiable objects, and I understand the desire in the collecting community, and I know that there are legitimate collectors, plenty of legitimate collectors whose hearts are in the right place, and they want the public to benefit from their collections. But that's not all that's out there, and we all know that. And at some point, a line does need to be drawn in the sand. And at what point do we say that people are on notice that there's a problem with the market? And there is a problem with the market. So in terms of the underlying premises of the white paper, I think the two fundamental legal distinctions that are sort of glossed over that I think really highlight what's at stake in the cultural property debates would be two legal issues. One is what is legally acquired. And I think that the definition is too broad. I think that when it comes to who should be on notice, the concept of due diligence should come in more strongly. And then where's the line between conscious avoidance versus a good faith purchaser? And again, I think that to defer to presuming that everyone is acting in good faith in the market goes too far, and to have a blanket, like a 20-year rolling rule, allows for plenty of people to engage in bad faith, even if the ultimate purchaser doesn't have any knowledge. Without much information, maybe it doesn't cross the line to conscious avoidance for criminal prosecution, but I don't think that's the way that we want to encourage our interactions with other parts of the world. So I am in favor of a market, but I'm in favor of a market that is undergirded by stronger regard for other people's property rights. If Venezuela can nationalize the oil fields as a matter of international law, I think these other nations certainly are within their rights to nationalize what's in their ground. I don't think there's any debate about that as a matter of international law. So I understand that people may differ as to policy, where is the best line, but I don't see anything extra legal here.
One of the ambiguities of the present circumstance of the AEMD guidelines is what 1970 means to anybody. When Egypt has 1983, when Italy has 1939, when Iraq has who knows what, I guess most recently total appropriation of anything older than 100 years. What does that tell you? And I want to ask the question, and I'm not even looking at anybody to jump in, about the public interest. Because at the end of the day, it's the connection between the public and the museum and the collector, and the collector and the trade that has made the American museums what they are. And that is in peril. I think it's fair to say it's in peril. And the point of the white paper, at least in part, is to address that chill, which historically has been so important when it's been warm and healthy and fluid. Mark.
I don't disagree with what you said. I don't think that we're seeing a great danger to property. What I was talking about is basically extra legal, because the document, the AAMD's document, is not a legally binding document at all. It's a statement of ethics. It's a professional statement. Any museum can go ahead and purchase something as long as they have met all the required pertinent laws and regulations. But what it has done, extra legally, is create a situation where those who wish to give, which is for the public benefit, who gets that? Is this public, and I could say in the American case, the need to know, it's vital to our nation because of our unique circumstances. It has had a very definite chilling, not only in the area of antiquities, but in other areas, so that what we don't see, while we have one case, a legal problem issues, and we've been talking about those, it's these unintended consequences that are not legal issues that is a matter of this splitting off certainly eroding to a very clear degree, widespread across the country, eroding the traditional means of support for museums, both to get collections and to get money to finance them. That's why I say it's not a legal thing. I agree with you that the property law, prosecutorial discretion has been actually very good. So it's not so much a legal thing, but a fallout of, in the case of the AEMD. I still have my problems with the way CPIA is administered, which I do not believe was either the legislative intent at all. And I guess I don't have much faith in Congress, but I guess I don't see how they can put up with it.
Well, if I might respond to what the public interest is here, I view museums, museums are second in our nation in terms of educating our public after schools. So as an educator myself, perhaps that resonates with me particularly, but I view museums as tools for education, not for tools for acquisition. And in the context of Nazi looted art, there was a large, there's been a large debate over deacquisition, and those same public policy arguments were made. And one of the things that I responded in regard to that is, well, as our public institutions, we shouldn't act as pillars of society. There's another competing public policy as well, that we're not going to traffic in stolen property and lots of instances, but property that was stolen in the most heinous way in order to support an evil regime. So there's a public policy that's broader than just we want to see the stuff. And I love this stuff. I love museums. And I take my students, when I teach art law, be it in this country or another country, or cultural property law, I take them to museums and I meet with dealers. And I have bought and sold things. And I have helped people buy and sell things. And I've helped museums acquire things. So it's not that I have a problem with stuff per se. It's not that I have a problem with the market per se. But the way that the market is being conducted, it's too far afield. So I think that there has been a correction, and I think that some of the unintended consequences that have come about have been in terms of the expansion of the market since 1970, and some of the contexts, and I'm not talking archaeological context, but some of the historical contexts from which things have been taken have been really horrific. And that continues today. And so the idea of preventing those kinds of things from being traded on the market, there's a public policy in that as well.
Okay, so I do want to come back to this utility or lack thereof of a registry, the intent of which is to provide a level of transparency to invite legitimate claims to be made, to resolve what is not resolved, namely what's going to happen to this stuff. Because what has happened to it up to this point is over. Ron, what would be your advice to some trustees from Baltimore sitting in this self-same room?
Well, I think a registry is a nice idea. I don't think it's going to get legislated, one. Two, I think the idea that, let's say, someone who has antiquities in this country right now is going to register those pieces, I think is unrealistic. They'd be concerned about family issues, the tax man, all kinds of things. And I'm not sure what you get a registry, you get the legislation, contrary to what I just predicted, you get the registry, and then what happens? The source countries, then is the idea that the source countries who bring an action or get the feds to bring an action under the National Stolen Property Act or under the 1983 Implementation Act, is the idea that the source countries will be bound by that public registry under the legislation that will, if you will, immunize the registered pieces? Is that the idea? I'm not sure that's going to work that way. I'm not sure it's going to work that way. I think the better way to achieve what many of us, I think, here want to achieve is to, one, get the museums to stand up Whether or not they did it in the past, I don't know. I wasn't there. 2, to get the 1983 legislation made exclusive, thus, in effect, taking the National Stolen Property Act out of the equation. If you want legislation, that's the legislation I would want. I don't think we're going to get it. I think we're stuck with it. Harry Truman said it best. You take action to get results, and what you get are consequences. And we got consequences, and now that's what we're talking about here, the consequences.
Mark, how would it affect, speaking of unintended consequences, if the channel between a donor and the museum is closed and the donor can't make these gifts, and what's going to happen to this stuff?
Well, I'm going to play devil's advocate if you all don't mind. Right now, this is circular. First of all, I'm not sure that I understand the point of the registry. Let me comment on that. The point of the registry is by exposing this thing to international transparent scrutiny, if nobody raises their hand and says it's mine, then it's mine. Why would I do that if I'm an owner if I already have a good title to it, or I believe I have a good title and everything in the record says I have a good title, and it would be incredibly possible to challenge that. So I don't know when I'd want to do it. Number 2, if I wanted a database of important stuff, I'd probably go to Chubb and say, okay, guys, what have you got? And they will have, Chubb is going to have God knows how many tens and hundreds of thousands of things on the list of incredible value. And they could actually serve as a source for their clients, presumably. What was that?
Something good.
Oh, now what's the harm? Since this rule is in effect, we're all complaining about it. It's been in effect, the 04 rule now for 10 years, almost 10 years. The 08 rule for almost 6 years. 6 years, it has been 6 years. We have seen the market in this area decline, so we know that that's working, and maybe CPAC is having some impact on the Chinese market, though I don't think so. So we've seen it work. So if we let it go along a little bit further and let this play out, at what point are the museums, instead of being squeezed by the archaeologists and squeezed by their friends in Europe, at what point are they going to be squeezed by the cash register? And the fact that the donors are no longer there to help with, keep the doors open. That's number 1. But number 2, what happens to these objects? I've got this object. What am I supposed to do with it? Is there anything harm? This object's already out. It's presumed it's been imported legally into the United States, right? We all just agree to that.
Sometimes.
No. I mean, as far as we know, as far as the record goes, there's no challenge to this thing, and there are hundreds of thousands of things. Mostly, I'm sorry, they're just knickknacks, a lot of them, And I don't want to put them in the Pier 1 category, but, they're not that important. They may give you a thrill. I'm not saying a cheap thing can't give you a thrill. It does. But they're not that important. But what's wrong with letting these circulate in the private world? Is there anything wrong with that? I don't see that. But let me show you, what is the potential silver lining? By having a market that's still active, guess what? These can be sold to people abroad. They can go back to the country of their origin if someone, let's say an East Greek hit came out 80 years ago, been passed around. Okay, East Greek is where? Turkey, right? Okay. Let's suppose that a Turkish industrialist who collects all kinds of things, Islamic, wants to buy this thing and bring it back. And it came from Ephesus, let's say, okay? They can do that. And that's the major way in which the Chinese are getting things back. The Yuanming Yuan was destroyed, which was an 18th century palace, was destroyed in 1860 by the French and the British. Every Chinese child in China, in Taiwan, in Hong Kong has been taught ever since that that was an act of unspeakable barbarity. Today, 80% of what was left is back in China. Not one of those items came back thanks to an intergovernment negotiation. They've all been bought back by China, or, in one case, given back. 2 of them were given back by Pinot. So maybe there's a silver lining.
Let me try another unintended consequence with silver lining. Okay, museums typically, as the Walters does, has 85% of the collection in storage, heated and cooled, guarded and secured, 24/7, 365. We're open 35 hours a week. Do the math. Then you just have to figure out what portion of your budget is spent on things that seemingly had no public value. Let's imagine, for the sake of argument, all that stuff is digitized. So in other words, sort of like the Rosetta Stone, you've squeezed everything out of it. What if these were to re-enter the marketplace exactly as you just described?
Well, there's a difference between the original and digitization. But first of all, I'm a great big believer in digitization, extension of museums. I don't think that anybody can argue about that. But the experience of them is not the same, and there is some
Mark, but I
value
mean,
to
just
learning.
hear my point. It's
I'm
the
sorry, I
85%
misunderstood.
of the stuff that's in the closet, under the table,
Right.
under the bed, crappy knick-knack, ding-dongs, whatever the hell you want to call
I
it.
don't have a problem if you sell it to upgrade the collection, not sell it to operate the museum, but sell it to upgrade the collection in that same area. I do not have a problem with ganging a lot of indifferent stuff, except if you are a museum of record. And we only have in this country one museum of record, and that's the Metropolitan. The rest of us can hope to be representative, but the only one that can hope to be definitive is the Metropolitan. There you get into the public policy issues that Jen brought up of de-accessioning. Is this in the greater public? I'm a great advocate of what is in the best interest of the public. I also know that there is an academic interest that doesn't always surface here. And as much as we've progressed with digital imaging, it is no substitute, even though I heavily rely on stuff for visual research. I use it like a microscope.
Now, not so long ago, Mark actually raised us the idea, or at least the impression, that a normal person might get from the idea that 12 museum directors meet in New York to decide what the other 182 museums
Don't get me started.
be doing, including the Walters. And so I'm going to ask Ron what, and by the way, museums are confused. That's very clear. I read Max Anderson's art newspaper piece almost a year ago. And
Well, that's very confusing.
it was 822 words of confusion about confusion, so I don't know if that is something that's almost existential. But Ron, what do you tell a museum trustee from a not quite so Jim Dandy museum? How do they deal with all this kind of legalisms and moralisms and all this stuff? How do they sleep at night?
Well, they should read the guidelines very carefully.
That's right.
All right? They should read the Implementation Act very carefully. There's not much to read about the National Stolen Property Act. One or two court decisions. And then they should reread the guidelines and say, these guidelines give us museum directors, museum trustees, more latitude than is generally understood to make good decisions based upon our research, based upon due diligence, give us the ability to acquire things by purchase or by gift. In many cases where a quick reading would suggest we just ought to pass on it. So reread the guidelines and then try to push for a little bit of a change in the guidelines. A little bit of a change. But the guidelines today, the museums today are able, if they chose to, able to acquire pieces today, and they should do so.
So they should just do it.
Do it.
Okay.
I disagree. First, the museums aren't collecting, they're not acquiring knickknacks. I mean, they don't have storage space to acquire knickknacks. So the kinds of things that they're interested in accepting from donors are going to be significant objects or maybe something to fill a hole in their collections that they've been wanting for a while. They need to ask for that documentation, and they need to paper back as well as they can, including with affidavits from anybody who's alive who can assist them. And saying, you know, I saw that at somebody's house, and that type of thing. They need to document as much as possible before taking any acquisition. The AAMD registry, which I know that your museum uses quite often, is a good tool in order to be transparent. I understand the risk of putting something out there may mean that there's a claim. On the legal side, although the AAMD registry is private and not governmental, there's a potential impact on statute of limitations and laches arguments down the road, although it's my hope that museums wouldn't use that in order to defend claims, but we all know that that's what happens. That's something that I have taken issue with.
Paper back to 1970. How many have heard this story? Maybe I didn't make it up. Of the person in West Mexico, and somebody is having target practice on a little Holima dog. Mm-hmm. And so they come up to that person and say, instead of shooting it, why don't you sell it to me? And they buy it for $5 or the equivalent thereof. I think those are true stories or capture the essence of some truth. So what does that have to do with the hundreds of thousands of orphans out there and with due diligence? What does due diligence mean in that context for anybody who wants to do it?
I thought that's what the safe harbors were for. The safe harbors in Section 2016 of the 1983 Act deal with pieces not being imported. They deal with pieces in the country already. And your museum, when you were the head of it, looked to some of those safe harbors, properly so, and I think that the museum directors and trustees should do the same, continue to do that.
Under the National Stolen Property Act, engaging in conscious avoidance or not demanding that documentation is a real risk. And that's why we're seeing museums acquire so much less stuff right now from donations.
So Philippe de Montebello asked a good question about 6 or 7 years ago. He said, I'm presented with a piece that's unprovenance. It's a great piece, all right? I know that if I do not acquire it for the Met, it's going to go to Dubai, it's going to go to the Far East. I owe a responsibility to my museum. I owe a responsibility to the public. Do I allow that piece to just go pass and go on to Dubai, where it will be put in a private collection or under the bed or in a vault or end up in Zurich, and no one will see it for a century? Is that what he has to do?
He also has a duty to protect the purse of the museum, and buying things that have a very high risk of being stolen risks that they're going to be removed from the museum and that money will be lost. Most of the time the museum's not doing the purchasing, but the principle still applies. These organizations and the people behind them also have a duty to comply with the law and not traffic in stolen property. And the cat is so out of the bag that it's pretty hard to deny that many of the things in the market are infecting the market. The same is true with fakes. If a museum was presented with something fantastic and it was a very high risk of being a fake, it would be a very high risk to acquire. The same thing is true.
Andre Emmerich, that great dealer, now deceased, used to say, the source countries are now coming to us, having destroyed certain civilizations, and they want us to give back the pieces that the source countries destroyed.
This is real. Right now, China is trying to get... Have you all seen the exhibition up at Asia Society on Densitil, the Tibetan monastery? Go see it. Fabulous show. Densitil was this great 15th, 16th century monastery, which a major component of a central stupa was made out of the most beautiful, big gilt bronze figures. China shredded it in the Cultural Revolution. Well, bits and pieces of it got out, over the Himalayas, who knows how, and were, in my view, rescued. And now there is the chutzpah, if I can use that good Chinese word, to say we would like to have it back. I'm sorry. You need to pay for these incredible acts of unspeakable barbarity. I happen to agree with Janet. Look, if you think this thing is hot, maybe hot, don't buy it. It's real simple. You don't have to go to a lot of stuff. And I will not knowing it. And due diligence, the problem with the concept of due diligence is we are trying to impose today's standards for airclad documentation, ironclad, airtight, on different laws. As somebody mentioned now, we're in a new world, right? Yeah, we are. Okay. But remember, the old world had not only different laws, different practice, normative behavior was very different. It didn't keep receipts of all this, and this stuff passed for an estate. Maybe it was handed down 2 or 3 generations in one family. Then it's sold, maybe a small auction. But the original receipts aren't passed along. There's also the issue of the right of any owner to remain anonymous. I mean, are you going to compromise that right? Do I have a right to own my own property? So we are trying to. We have a difficult situation. There's nothing wrong with today's standards. I'm not saying that. But we have a difficult time when you apply them to a time when people behave differently, especially with respect to documentation.
I'm going to jump in here under the heading of time and sort of roll my mental tape back to what seems like a long time ago, but was 2 sessions ago. And somebody recounted a convening not unlike this one that took place 13 years ago and asked the question rhetorically, and it was answered, I think, what's different after 13 years? And so I'm going to leave everybody with this question. Is it going to be pretty much the same a dozen years from now or not? And if it's going in the wrong direction, or could, let's put it the other way around, could go in a better direction, does the white paper provide the beginnings of a roadmap toward a better direction?
No, because it's a remedial for problems, legal problems. The big issue you want, in my mind, is the almost impossibility of establishing illicit markets. That would be great if we could all be like Japan. Let's all be like Japan. That requires an intelligent bureaucracy. Is the rest of the world so unintelligent they couldn't do this? All they have to do is copy the Japanese system. It's there. But I think that would solve so many of the whole world's problem. I wish the Chinese would start buying impressionist pictures, to be honest with you. These are the kinds of things I think is very important for this whole globe.
So
that is the
fundamental change is outside the control of
fundamental change
players.
Fundamental change until it is in its political suicide in many foreign countries. I mean, just go into Egypt.
No, I hear you. Ron has an opinion here.
I don't think that tombaroli right now are the biggest problem. Right now, the biggest problem are howitzers. Right now, the biggest problems are, barrel bombs, blasting the hell out of Aleppo. Or in the old days, it used to be Moshe Dayan excavating with a howitzer. But this, to me, I mean, the amount of destruction that is caused by civil disruption is appalling. In American museums can't do
I'm going to restate the question. Against the backdrop of gloom, what, Ron, and then Jen will be last, may be within our power, connected or unconnected to the white paper, our power being those within the boundaries of the United States, policymakers, guideline makers, lawmakers, to make a better future?
Change is always there, but good change comes from education. I saw in 1974 Christie's catalog in which they were selling a piece of art that was identified as having been seized by the Nazis. And in 1974, no one said a word. It went and sold at Christie's. It's not a dig at Christie's. It's that things change. Now it would be unheard of.
Yeah.
All right? So things do change, but they change with education and with thought. And that's what we're doing here today.
Jen?
That is wrong now, to acquire things that you know are stolen, and it was wrong then. At some point, everyone's on notice as to what the deal is. In terms of the guidelines, the AEMD guidelines allow for a case-by-case loophole. I mean, if something is absolutely extraordinary, They've done the due diligence that they can. They can't find any evidence of it being looted. They've reached out as much as they can. I understand that source nations don't always give a response, but if they've done all that they can, they still do have the power to acquire and post it on the AAMD registry. So I don't see the changes, Bill, respectfully, in the paper as ones that are needed. I think that my statements when I started, I think, say all I need to.
I think the changes are needed. Do I think that it will solve the bigger problem of how can we, unless you do not believe that it's good for humankind as a whole and nations as a whole to have an exchange of cultural properties. If you don't believe that, then no point in trying for even getting an illicit market.
The last time somebody stood at that podium is the same person when this all started, which means to say this is where it ends. But having said that, don't clap, please. Yet, I would like all of those players who are kind of part of this happening, members of the Committee for Cultural Policy, the hero of the day, beat up a little bit, Bill Pearlstein, to stand up. Because we're going to go out to a cocktail party and you want to find them and you want to express to them what your opinion is, which you haven't had a chance to do yet because they yak so much from this end. Come on. Arthur, don't be so shy. That's not like you. Who else is in this little coterie? Oh, there. Okay, I'm done.
Good panel, good moderation.
Thank you all for attending today. A huge thank you to all of our distinguished panelists for their participation. Thank you to Professor Schroeder, Arthur Houghton, and Gary Vicken for moderating these panels, and to Kate Fitzgibbon for being the mastermind of the event. Just one note before we adjourn to the lobby for the reception. If you've registered for CLE, you must sign out at the registration table. And if you registered before Monday, your certificate of attendance will be available at that table as well. Thank you, and please join us for the reception.